matter be taken up on the next Thursday. Because it is not that the state is to be blamed or anybody is to be blamed. The system is to be blamed for that. We have become too much techno-savvy. Techno-savvy cannot give the intelligence.
But in the Ramakrishna Vivekananda mission, Mr. Kishore Bhatt had concluded the
open stage.
Yes, that I.
Income tax matter. 24 matter, Lordship, now it has been covered by a Supreme Court judgment with respect to limitation. The
Rajiv Bansal.
yes, Rajiv Bansal matter.
Which year?
This is the 2024 writ petition.
No. Which year is assessment year? Is which year?
Prior to it is covered by that 2021's post 2021, not covered by the TOLA regulations. Lordship, it could be taken up subject to Lordship's convenience.
দিয়ে দেবেন ওটা ফাইলটা একবার দেখিয়ে নেবেন. You write your grounds of urgency because I'll forget.
Oh, okay.
Yes. Give write your grounds of urgency. Give it. I shall see in the chamber, and if I find that it is meritorious, I'll upgrade. Yes.
May I be permitted to mention two hearing matters for Mr.
Inclusion, please give.
Yes, sir. May I permitted to mention one new motion, my lord, for inclusion.
Inclusion, please give. No need to mention. Yes, Mr.
Permitted to mention two matters. One for inclusion of cancellation of GST, that I have mentioned, Lordship has allowed earlier, but it's not coming in
ওটা উপরে cancellation for what? Non-filing of return.
non-filing of the share.
ওটা উপরে দিয়ে দিন urgent to submit.
I'm sorry to bother, my lord. There is a matter pending before your lordship, GST matter, 729 of your lordship. We have come up for late filing of appeal, and appeal has been dismissed on the ground of time.
That is being heard on that point.
17th,
it is being heard
on the
yes.
17th.
It was heard on 17th. If it is within condonable period, I'll upgrade. But if it is beyond that, after the hearing is over.
Only one difficulty, more than 20% has been deducted recently.
But I will not be able to upgrade in view of the Supreme Court judgment where it has to be clarified.
Around 17/7/2025 by Honorable President. I can see that we have purchased goods from Amu. They did not show it in their data. They are very small here. Huge tax liability. Since then, 17/7/2025, matter has not been.
What I be challenged? Adjudication order. দিয়ে দিন. Why don't you deposit 10%? I'll stay it because in any case.
Well, at the time of filing appeal,
that was for the purpose of 107.
Yes.
112 also there is a provision.
well, it's a very small case. But the thing is
Even
that
then, if I have to go into merits, then in that case, affidavits will be required.
well, I'll show if the matter comes, Your Lordship,
Give it, write your grounds of urgency and give it. Yes, madam.
Yes, my lord, I have written, my lord.
Give it, I shall see.
Matter was heard on 29 January 2025, my lord, wherein Honorable Justice Rajesh Bhardwaj was pleased to pass a stay order, my lord, upon payment of 10% of tax and dispute, my lord. Despite making such payment, we have paid to 30 lakhs. They have recovered 30 lakhs 74,000. Again, in the month of February, my lord, they have recovered
Despite
22
stay.
lakhs. My lord.
Despite stay,
Yes, my lord.
although stay is there, they are recovering.
My lord.
Peculiar. देखिए दीदी दिए देवे नोटा क्या ना होती है.
Your Lordship, may I be permitted to mention for extension of date till expiring the month of
Extension, please give.
Your Lordship, one more matter. Therefore, inclusion of the matter in the list.
Inclusion, give. Yes. Why?
That account has been settled. My lord, after it came to know that his cell number has been used by some key center and
What will writ court do in that? What will writ court do? It's a case of fraud, something has happened. Writ court cannot come to your rescue.
GST is
Even if GST, they will have to investigate whether fraud has been committed or fraud has not been committed. It's a case which is a story being made out. How will writ court intervene into that? Yes,
my lord, for extension of interim order.
please give.
My lord, one matter you must see. Here, my lord,
Please write your grounds of urgency, give it, I shall see. It may not be upgraded, may be upgraded. I shall go and see the file and then I shall upgrade.
From mentioning for extension of interim order.
My lord, they have recovered money from my bank.
Very well.
Mentioning for extension of interim order.
Extension, please give. Didi, call করুন.
Well, this is
One, কি হলো আবার এতে?
okay.
Yes.
This is the letter from the client, my lord. The period is 15-16 is barred by limitation, although the assessment order has been passed, my lord. So client wants to avail the alternative remedy available to it. Time may be excluded, my lord. We have filed a petition challenging the assessment order also, so my lord. Kindly give the liberty to file the appeal before the CIT appeal.
But if you withdraw, then in that case, liberty will.
My lord, time
I can do this. When did you file the writ petition?
20 February 28, 2025.
And when is the assessment order?
March 30th, 2025.
20?
After that, 30th March 2025.
25. Very well. Then
My lord, I think day before yesterday also passed in for the period of 15-16.
Yes.
This is barred by limitation. And I have taken, but the assessment order has been passed. So
লিখে নিন।
I think
Uh,
supplementary affidavit. This is the assessment. We have annexed the assessment order.
Assessment, I had already brought on record, my lord.
On the last occasion,
On-
I have brought on record.
No,
It is my duty, my lord.
that is the knowledge of the.
My lord, learned friend cannot deny the fact that affidavit have already been affirmed before that one.
10th April 2025.
Yes,
Supplementary.
yes, ma'am.
That's why, my lord.
It is my duty when on the last occasion I could not submitted the assessment supplementary affidavit due to the fact, well, he was not willing to take up the matter because of the reason the assessment order has been passed. So I prepare the supplementary affidavit as soon as I get the information from the client. Matters will come up for hearing subsequent to that.
Very
It
well.
is apparent from the record itself.
This writ petition has been filed laying challenge to where is the notice which you want to challenge?
Page 84 of the petition.
Page
Assessment year 13-14 dated 25th of December 2023.
Page 84.
84, madam. 84 of the petition, annexure P13.
Laying challenge to a notice dated December 5, 2023, issued under section 148 of the Income Tax Act, 1961 for the assessment year 2013-14. Full stop. Paragraph. This writ petition was filed on February
28.
2025, full stop. During pendency of the writ petition, the order of assessment was passed on
30th March 2020.
March 30, 2025,
Page number 5
full
of the
stop,
supplementary.
paragraph. The said order of assessment has been sought to be brought on record by way of a supplementary affidavit, full stop. As prayed for, leave is granted to file the supplementary affidavit, full stop. Supplementary affidavit filed in court today is taken on record.
Great.
Full stop. Paragraph. Since an assessment order has already been passed, therefore, the petitioner seeks liberty to approach the appellate forum, challenging the assessment order, full stop. In such view of the matter, WPA 4998 of 2025 is dismissed with liberty to the petitioner to approach the appellate forum, full stop. Since the assessment order has been passed during pendency of the writ petition, therefore, the period during which this writ petition remained pending before this court shall be excluded for the purpose of computing the period of limitation
Great.
for preferring appeal before the appellate authority under section 246A,
Yes.
capital A, of the said Act of 1961. Full stop.
Only period may be mentioned, period for the 13-14, the assessment.
Mentioned it at the top.
Yes.
13-14 I said. Because writ was filed earlier.
I am not on that.
And the time
On the last occasion
the
when the
Supreme
matter
Court-
was taken up before Justice Rajabasu Chaudhary, I had informed the court that assessment order was on that date my learned
from the court,
my
subject to correction
no,
to
no.
my learned friend,
and I
both
also filed
informed
a
the
copy
court because I
and
was
my
carrying
learned also informed the court.
I was carrying my
That is according to
supplementary
the order also.
Yes, my lord.
Earlier order it is recorded.
That's why
Yes,
I'm-
I am carrying. It was my lord is of the view that I cannot take the supplementary affidavit without the leave of the court.
and the why
That it is my duty to.
my lord, why the petition was kept pending by the my lord? Because my lord had a doubt whether a notice under section 148 can be issued twice or not. That my lord had inquired.
Already
with me.
tested by the appellate.
Yes,
authority.
the
Appellate
client's call we cannot do. Madam. I was very confident about the fact that I can get the order from the court.
You are
Right
also-
now, the Supreme Court has already held, my lord, that there is the observation of the ASG. He has considered for the period of 13-14 and 14-15. Great.
Very.
Well, this is the extension of interim order, but only difficulty is that. কি বুঝলাম না? Well, they have already in view, there is interim order passed by your lordship, but subsequently they have withdrawn some of the amount without. Then they have written to the letter to us.
For the first time, I
don't have any
particular instruction.
পাঠিয়ে দিয়ে দিচ্ছে দেয়নি তো refund. But then my lord subsequently they have advised me to file an application for refund on 18th to me. We have filed application for refund. না জানি করে প্রয়োজন আমি জানি
You take instruction.
Inadvertently, they have paid it already.
So what they have reversed it.
No, not yet. They have asked us to file an application for refund. And we have
Why?
filed an application refund on 18th.
They should do it suo motu. They have done it during subsistence.
My lord, if they have done it, they should do suo motu. They have
Yes.
done it, they should do it suo motu.
I'll ask them.
Because
No, they have to
inadvertently,
do it. It's not a
Absolutely, Your
question of
Lordship.
asking.
absolutely they have to do it.
No question of making application or because they are in contempt otherwise.
It will be,
Brazen contempt.
I will,
Order of stay.
I will convey your
They have to
lordship.
do it immediately. Lieutenant, this matter is appearing under the heading extension of interim order upon being mentioned therefore. Full stop. Heard learned advocate appearing for the respective parties. Mr. Mojumdar, learned advocate appearing for the petitioner submits that despite an order of stay, what was the interim order? Despite an order restraining the respondent GST authority from taking any coercive action being there in subsistence, comma, the respondent GST authorities have proceeded to recover certain amount from the petitioner from the petitioner's electronic cash ledger.
Yes, electronic cash.
Electronic cash ledger. Full stop. Mr. Sanyal, learned advocate appearing for the respondent submits that he has no instructions in such regard. Full stop. Paragraph. In case the respondents have acted in violation of the order of the interim order passed by this court, of the subsisting interim order passed by this court, comma, they would remain obliged to reverse the action in order to avoid proceedings for contempt. Full stop. Paragraph. The subsisting interim order, therefore heard learned advocate appearing for the respective party. Subsisting interim order shall stand extended till the end of April 2026.
Great.
Or until further order, whichever is earlier. List this matter for hearing in the combined monthly list of March 2026.
Great.
Yes.
Next matter is also same, but the period is different.
Same reversal there also.
Yes, sir. No, there
Recovery is not
only
there.
extension for it.
Has to do extension. The affidavits are complete.
Pleadings
Yes.
are complete.
What is the matter?
My lord, is it 16(2)(c), my lord, the violation of 16(2)(c), we are saying that there is a retrospective cancellation of registration of the supplier. My lord, I cannot be penalized. My lord,
It is required to be heard.
it is because many matters are there, my lord, it can be tagged together. My lord, I
Next
can
week,
give the list.
March onwards, I will streamline it a little more.
My lord, my suggestion would be, I can, my lord, we all my lord, can prepare the
List of
List
cases so
of
that we
cases,
can
registration
take in bunches, 16
Yes,
to
madam.
3 one day. For example, the delay matters are going on.
delay matters,
Once they are streamlined, lot of matters will go.
like income tax is barred by limitations
Yes.
and all period.
registration cancellation.
Income tax barred by limitation matters, you can give it today itself or in this week itself,
madam.
maybe by tomorrow.
Yes, madam.
So that in the next week I can bring up some matters and finish it in view of Rajiv Bansal if something
Yes,
is
yes.
pending.
For 2 period.
Yes,
That period I would to argue my
yes, yes.
After
For 2
15,
periods
16,
which are covered.
yes, well, after 15, 16, 16, 17, we have to argue my lord. There is,
Give the cases.
yes, madam.
Lieutenant, this matter is appearing under the heading extension of interim order upon being mentioned therefore. Full stop. Heard learned advocates appearing for the respective parties. Full stop.
My lord, I was, my instruction is otherwise, my lord. The second matter, my lord has passed the order, that has to be taken into consideration. Otherwise, my lord, in the second matter, they have recovered, not in the first matter.
মানে in this one they have recovered.
Yes, my lord.
ওই আগের অর্ডারটা ওটা হবে আপনার 4 নম্বর আইটেম allied exim.
No, no,
My lord,
Allied exam, I am appealing.
Saha Mondol, my lord.
Shah
Item number 4.
Saha Mondal have passed that order.
My lord, in the first matter, 2 matters there. In the Saha Mondol.
Yes.
First matter they have recovered. Second matter they have recovered. From the first matter they have not recovered.
আচ্ছা তাহলে এই 2 নম্বরের যে অর্ডারটা হলো সেটা 3 এ হবে।
My lord, only thing, my lord, just 1 second, 1 minute. I
Yes.
just had a talk with the officer.
হ্যাঁ
he says that first of all he's unconditional apology, it missed his the order he missed. He says there has to be something on the portal for him to revert back.
So that he has to do it.
We cannot, but as a the portal works, there has to be some application. Some
This
application.
order will be uploaded on the portal.
Yes, or
On the basis
some
of-
application, immediately it will be reversed. No process.
That you have to request the assessee. I will not pass a judicial order for reversing something which has been contemptuously done.
Absolutely, it's
I will
absolutely
not
act
do.
of contempt. But I'll request if immediately it will be done. I have been told an
you
apology
request
letter has
the
also been
assessee to
written.
do, because that will not look good.
Yes, do it kindly. I'll
violate the order of court and then
no, let the assess let the department get
yes, he'll
access
take
to
it
the
over with the assessee.
assessee.
এটা 3 অর্ডারটা হয়ে গেছে। 3 হয়ে গেছে, আগে যেটা হলো ওটা 3 রেকর্ড করবেন, আর 2 এটা রেকর্ড করে নিন এখন। একই কস্ট টাইটেল আছে, হ্যাঁ, এই জন্য এটা ঝামেলা হচ্ছে। সাহা একই কস্ট টাইটেল, যেটা আপনি রেকর্ড করলেন সেটা রেকর্ড করলেন 5276 এ, ঠিক আছে, আগের যেটা ওই কন্টেম্পটের ব্যাপারটা, আর এখন রেকর্ড করছেন 5268। Heard learned advocates appearing for the respective parties. The subsisting interim order shall stand extended till the end of April 2026 or until further orders, whichever is earlier. List this matter for hearing in the combined monthly list of March 2026. Next.
Item number 4, I am appearing virtually, my lord.
Yes.
I am praying for extension of interim order, my lord. Affidavit in opposition has not been filed yet.
Not been filed, your lordship.
Affidavit in opposition
Petition has not been filed, your lordship. It has not been filed.
not yet ready. Why?
26 matter, your lordship.
So
Kindly give me some time.
this matter has been listed under the heading extension of interim order. Upon being mentioned therefore, Mr. Sanyal, learned advocate appearing for the respondent, learned advocates appearing for the GST authorities,
For the central GST.
seek further extension of time for filing affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within 3 weeks from date. The extension also 4 weeks. Full stop. Affidavit in reply thereto, comma, if any, comma, be filed within 2 weeks thereafter. List this matter for hearing immediately after expiry of the time fixed for exchange of affidavits.
168.
The subsisting interim order shall stand extended till the end of April 2026.
Lordship,
I'm grateful.
160, these are all 168 matters. So the central will be filing.
File. You will also be affected.
I'll be
affidavit
affected,
will-
but your lordship, instruction 168.
If the notifications are struck down, you will also be affected. Then
Well, notifications were issued by both the state and the union.
that is why both of them should file. That is what I am also.
Yes.
Yes.
I'm grateful, man.
I'm appearing for the state testimony, lordship.
Yes.
10 and 12.
Yes, sir. What is this?
Malad,
matter?
I'm for the petitioner, Malad. Malad, I have a strip of land, Malad, in Dag number 3883. If your lordship kindly sees in page 15.
Yes.
And that has been blocked by the private respondent, Malad, and seriously, Malad.
No, but this plot of land belongs to you.
Yes, Malad. The record
So
of
how
rights.
is this an unauthorized occupants matter? I don't have determination for that.
Your lordship.
If it is for removal of only unauthorized construction on some such land, it's either violation of Panchayat Act or something else. It's not under unauthorized.
Land.
I will have determination only if it is unauthorized occupation of a government land.
Yes, Malad. Your lordship kindly sees
Yeah.
sometimes.
You say it is your land.
No, Malad, the land in front of my land, the government land has been.
That
Your
is
lordship
government land.
Yes, Malad, kindly page 24, Malad.
Page 24.
24.
If your lordship kindly takes up the second
Yes,
paragraph.
encroaching government land. And who is appearing for the private respondent?
Petitioner number 10 and 12.
You are appearing. Very good. I am directing the state to consider his representation. He'll give you a hearing. Both of you will. I will record that you are not admitting, and he will issue notice, give a hearing to all, and pass a reasoned order.
Consequential step may be taken also.
Yes, of
Yes.
course. Only if they are found to be in unauthorized
Yes,
occupation.
unauthorized.
This writ petition alleges inaction on the part of the respondent state authorities in
Respondent number 4 is the competent.
in taking steps for removal of alleged unauthorized encroachment on government land. Full stop. Paragraph. Learned advocate appearing for the petitioner invites the attention of this court to a representation dated November 2, 2023, addressed inter alia to the subdivisional officer, Tehotto, i.e. the respondent number 4 herein, and submits that despite a complaint having been lodged before the said respondent alleging unauthorized occupation of government stroke public land by the respondents numbers
10, 11 and 12.
10, 11 and 12, the said respondent has not taken any step whatsoever in the matter. Full stop. Paragraph. Learned advocate appearing for the respondent numbers 10 and 11.
10 and 12.
10 and 12. 10 and 12 submits that the petitioner's allegations are baseless. Full stop. It is submitted that the respondent numbers 10 and 12 are not in occupation or not in unauthorized occupation of any government land as alleged. Full stop. Paragraph. Since a representation has already been made before the respondent number 4, and there is dispute as to whether the property in question is government land or not, it would be appropriate to direct the respondent number 4 to take appropriate decision in the matter. Full stop. Accordingly, the respondent number 4, i.e. the subdivisional officer Tehotto, is directed to consider the petitioner's representation dated November 2, 2023, within brackets annexure P2 at pages 24 and 25 of the writ petition, bracket closed, and conduct relevant inquiry to ascertain as to whether the petitioner's complaint is genuine. Full stop. Paragraph. If the respondent number 4 finds that there is merit in the petitioner's representation, the respondent number 4 shall take appropriate steps in terms of the relevant statute, including West Bengal Public Land, within brackets eviction of unauthorized occupants, bracket closed, Act, 1962. Upon and initiate appropriate proceedings. Full stop. It is needless to it is clarified that while undertaking any inquiry and conducting any proceeding, as aforesaid, the respondent number 4 shall notify all interested persons, including the petitioner and the respondent numbers 10 to 12, and shall permit all such persons to state their respective cases before the respondent number 4, before arriving at the ultimate decision. Full stop. Paragraph. In case it is found that any person is in unauthorized occupation of the government land, stroke public land, comma, the respondent number 4 shall take appropriate steps to ensure removal of the encroachment. Full stop. It is expected that the respondent number 4 shall conclude any proceeding that may have to be initiated for removal of encroachment in terms of for removal of encroachment, comma, in terms of the relevant statute, comma, as expeditiously as possible and preferably within a period of 12 weeks from the date of communication of this order. WPA 1759 of 2024 stands disposed of.
But affidavit of services are
Affidavit of service.
original deed petition and the mentioning evidence.
I appear for the writ petitioner, Lordship.
My lord, item number 6, I beg to appear for the private respondent. I raise the, my lord, points of maintainability at the threshold, my lord.
Why? Why
My
do you
lord,
say it's not maintainable?
My lord, on two grounds, my lord. First come first, my lord, this is a contempt application and that has been filed in the style of writ petition, my lord.
That is not a ground. That
No,
is
my
not
lord.
a ground.
Yes, my lord, this is...
Contempt application is not necessarily required to be filed in case of violation. Writ petition is maintainable. Next ground.
My lord, next ground is another writ petition is pending before your lordship. This is also same, my lord. A can also has been filed, my lord. This is WPA 11944 of 2023. It is, my lord, Surjo, my lord, this is of the same relief, my lord, same annexure.
Yes, sir.
I don't know about this other writ petition.
No, but you
Lordship.
have to know if
I have
there
to
is
take
an earlier
instance.
petition pending, then this is
What
this has to be dismissed.
this writ petition, Lordship.
My lord,
there
this
has-
is my lord. Before my lord, may I just once, my lord, kindly come to page number, my lord. My lord, the first annexure, my lord, page 15.
Page 15.
This is, my lord, a court order, my lord, passed by Honorable Lordship, Honorable Justice Shobboshachi Bhattacharya in the matter of, my lord, Shankar Maiti versus State of West Bengal and others. The same Shankar Maiti, my lord, have preferred a writ application. This is, my lord, WPA 11944 of 2023, Can 1 of 2025. This is also appeared before your
I have
lordship.
to take instruction, Lordship.
And my lord, Shankar Maiti has preferred this application. Now, my lord, this person is Suraj Kumar Maiti. They have filed this application to implement the order of Shankar Maiti.
So what? So how are you saying it is the same application? The writ petitioner is different here.
Lordship, there has
My
been
lord, the prayer is same.
Why should the order not be implemented?
There has already been an
I-
order by the concerned SDO. We are seeking the implementation of that order.
And who are you to prevent the implementation of the order?
No way, my lord, I
But
cannot.
then you keep quiet. If you don't have any
My lord, he was
ground
not a
to
party
say-
in the writ petition, my lord.
Huh?
He was not a party in that writ
Not
petition.
required. Not required. He says that there is an encroachment on government land. There has been an order passed in a writ petition saying that the encroachment should be removed. That order has also not been complied with. He has a cause of action saying there is encroachment on government land. Any person can come.
Is my lord, my only submission is, my lord, the same writ petition is pending. He is he is Suraj Kumar
Not
Maiti,
Shankar
another is
Maiti.
Shankar
Before this
Maiti.
court today is not Shankar Maiti. When Shankar Maiti's writ petition comes, you can take the point. This is Surjokanto Maiti, different person. He can maintain the writ petition.
Lordship, page 17 is the order where the concerned SDO has already directed the BLLRO to remove the unauthorized occupants.
Yes.
The schedule is the land where the unauthorized occupation has taken place. If Lordship comes to point 3 of page 17, if I may place it, the block land and land reforms officer Narayan Gaur shall submit an action taken and report to the undersigned after completion of the eviction
Where
right.
are you reading? Which portion are you
The below the signature,
reading?
page 17, Lordship.
Page 17, yes.
Page 17. Copy forwarded to number 3. Page 17 is the order by the concerned subdivisional officer directing removal of the unauthorized occupants.
And how are you aggrieved by this unauthorized occupation?
Lordship, my land is adjacent to the public land where the unauthorized occupation has taken place, and this is my specific case that they are raising construction not only on the public land and also on the adjacent PWD road, and my only access to the PWD road is through that land, and therefore my access is completely lost, and that's why I am aggrieved. Previously there was a writ petition by my brother where a direction by Honorable Justice Sabyasachi Bhattacharya on the subdivisional officer was made, and he was directed to take actions under the Act, Unauthorized Occupants Act. Such action has resulted in the in page 17 order. It has been passed in 2024, 30th September 2024, and we are standing in 2026.
This writ petition.
My lord, before passed an order, may I just submit one thing, my lord?
Yes.
Yes, my lord. My lord, can it be taken up together, my lord?
No, I'll take this up today. It is before me today.
Because,
Whenever
my lord,
that comes up, we shall see.
Because, my lord,
this petition has been filed alleging inaction on the part of the respondent state authorities in removing encroachment of an unauthorized construction over government land. Full stop, paragraph. The writ petitioner it is the writ petitioner's case that earlier, the petitioner's brother had approached this court by filing WPA 8252 of 2020, alleging inaction on the part of the respondent state authorities in not taking steps for removal of encroachment despite representation in such regard having been made to the respondent state authority state authorities. Full stop, paragraph. Such writ petition was disposed of by an order dated December 22, 2021, thereby directing the respondent number 5 therein, i.e. the subdivisional officer Kharagpur, to dispose of the petitioner's representation, to consider the petitioner's representation in accordance with law upon giving adequate opportunity of hearing to all interested parties. Full stop. Paragraph. In terms of the said order, comma, the subdivisional magistrate, comma, Kharagpur has passed an order dated September 30, 2024, thereby directing a removal of unauthorized removal of encroachments over the subject government land and recovery of possession thereof. Full stop. Despite such order having been passed, comma, since the encroachments still remain, comma, the petitioner has approached this court. Full stop. At the outset, comma, learned advocate appearing for the respondent number. You are for which respondent?
Private respondents.
Respondent numbers 8, 7 to 11. No, 8 to 11. 8 to 11. 8 to 11 submits that this writ petition is not maintainable in as much as the petitioner was not the writ petitioner in WPA 8252 of 2020, and as such the petitioner cannot seek implementation of the order dated cannot allege contempt of the order dated 8252 of 2020. Full stop.
And my lord, another writ petition by petitioner's brother is pending.
It is further submitted that another writ petition at the instance of the petitioner's brother,
WPA 11944
number
of
is not
2023.
who was the writ petitioner in WPA 8252 of 2020, is also pending before this court. Full stop. Paragraph. Heard learned
And my
advocates.
my lord, a title suit is also pending.
That is irrelevant.
Yes,
Heard
my lord.
learned advocates appearing for the respective parties and consider the material on record. Full stop. As regards the first ground taken by the learned advocate appearing for the private respondents, comma, the same would not detain the court for long. Full stop. It is evident from the tone and tenor of the writ petition that the writ petition is based on a different cause of action, in as much as it now seeks implementation of the order passed by the subdivisional magistrate, which has not been executed despite having been passed on as far back as on September 30, 2024. Full stop. That apart, it is evident from the order dated December 22, 2021 that the same had directed, that this court had directed adequate opportunity of hearing to all interested parties being given. Full stop. The petitioner, who claims to be residing by the side of the same government land, encroachment whereof has been alleged by the petitioner's brother in the earlier writ petition, is definitely an interested party. Full stop. In such view of the matter, comma, this writ petition can be entertained. Full stop. That apart, within that apart, it is not the law that for every violation contempt is the remedy. Full stop. An independent writ petition can in certain cases always be maintained. Full stop. Paragraph. Having heard the learned advocate, in the instant case, comma, since an order has been passed by the subdivisional magistrate, upon initiating proceedings under the West Bengal public land, within brackets, eviction of unauthorized occupants bracket closed Act, 1962. In terms of an earlier order of this court in WPA 8252 of 2020, the said order must be executed and implemented unless the same has been stayed or otherwise interfered with by any higher forum. Full stop. In such view of the matter, this writ petition is disposed of by directing the respondent number 4 to take expeditious steps to respondent number 5.
Respondent number 6 has been directed by respondent number 5.
Respondent numbers 5, he will take steps. Respondent number 5 to take expeditious steps to ensure implementation of his order dated September 30, 2024, within brackets page 17 of the writ petition, unless such order has been stayed or interfered with by any higher forum, within a period of 4 weeks from the date of communication of this order. Full stop. You are appearing for?
Private response.
State is not represented.
Affidavit of service, Lordship.
WPA 28532 of 2025 stands disposed of. Affidavit of service filed today is taken on record. None appears for the state respondents. Ekdam upore likhe debe na. None appears for the state respondents despite service. This was government pleader's office.
Government.
Despite service.
Grateful, my lord. Grateful.
Can কিসের জন্য আছে জানি এইটাতে কি can আছে চারে দেখি কি আছে
কপি দিয়ে দেবো এইটা হ্যাঁ তুমি ফাইল করে দাও আমার করে দিচ্ছি
ডিসপোজ অফ আগেই হয়ে গেছে লেখা নেই থাক ছেড়ে দিন ওখানে লিখে দিন একটা ওখানে লিখে দিন যে ওই দিন আমি বলে দিচ্ছি ওরা তো আবার নেই থাক পরের দিন যখন আসবো তখন করবো অলরেডি এক্সটেন্ডেড হয়ে গেছে ক্যান আর থেকে কি হবে চলো yes
I already filed my notes.
Mr. Sen, Mr. Tiwari, in one matter, somebody was telling that there is some state notification which has, for some area, case appeals from SDM will lie before the DM. That was submitted. I have not seen the notification as yet. No, because I have a
one typographical mistake that might
yes, not a problem. I am recording the order. You give it. And Mr. Sen, since so many judgments and a lot of material is there, I shall keep it one more day in the next week, Because I shall go through it, maybe because after I close hearing, I would
No,
not
no.
like to bring it as to be mentioned.
And in the
but
meantime,
it
also
will be
ascertain whether there is any notification or not.
Yes.
If the notification is
So,
there, not
one more day I'll keep it. I'll go through it myself. Maybe something comes up, something may not come up also, but still.
and notification is also important. If notification is there, my lord, my case is tended.
I'll take your lordship. Heard Mr. Sen, Mr. Tiwari, learned advocate appearing for the petitioner, and Mr. Sen, Mr. Tiwari, learned senior advocate appearing for the petitioner, and Mr. Tiwari, learned senior advocate appearing for Mr. Sen, learned senior advocate appearing for the respondent number 2 and 3. Full stop. State is unrepresented.
State is always virtually present.
Full stop. Written notes filed on behalf of the respondent numbers 2 and 3 is taken on record. Pore diye deben onar kache o ki correction ache pore diye deben. Please file it today because I have written. List this matter for further consideration once again on February 26, 2026 under the same heading. ওই continuing matter হিসেবেই 26 তারিখে দিয়ে দেবেন তাহলে
Can it be on my lord 5th March?
I'll just close.
I may not be there, my junior will.
Okay.
I am for the petitioner. Affidavit of
890.
In this matter,
Somebody is unwell. Give your affidavit of service, I'll take it on. What is this matter? Unauthorized occupation?
yes, my lord. My lord, the road is the BSF road. The private respondent, my lord, made unauthorized construction the side of the BSF road in front of the land of the petitioner.
It
And
will
my
be
lord,
only
already
private respondents are also not there.
already, my lord, BSF has taken its steps and issued a notice to the officer in charge as well as the subdivisional officer, but the subdivisional officer did not take any steps.
Very well. Affidavit of service filed today is taken on record. Learned advocate appearing for the respondent number 1. In such view of the matter, let this matter stand adjourned and be listed again on 26th.
Good.
February 26, 2026. Next.
Lord, the unauthorized construction had already been demolished, and Lord, the matter to be
Very. लिखे नहीं. The report in the form of affidavit filed on behalf of the respondent number 3 is taken on record. Full stop. The said report reveals that a final notice dated February 3, 2026 had been issued by the Block Land and Land Reforms Officer Potashpur-1 to the encroachers, for removal of the encroachment on government land, full stop, Mr. Dolopati, learned advocate appearing for the petitioner, submits that in terms of the notice, unauthorized encroachment over government land of government land has already been removed. Full stop. In such view of the matter, nothing further remains to be decided in this writ petition. Full stop. WPA 6805 of 2025 stands disposed of with the above observations. A report on record. Yes, next.
I appear for the petitioner. This is one of the unauthorized construction made to the PWD roads and
Serve a notice number. None
Ar-
appears. None appears for the respondents. Full stop. The petitioner shall serve a notice on the non-appearing respondents, as also on the office of the learned government pleader, intimating them that this matter shall be taken up next on February 26. Within February 2026, you'll be able to serve all.
My lord, the February 26th and civil, Purbo Medinipur,
All respondents. will be
only
able to-
private respondent, singular private respondent is there.
So within 6.
26
February
days on a 20, no,
on March 5.
March 5.
March
yes.
5, 2026. Chalo. And file affidavit of service on the next date. Next.
My lord, I am for the petitioner. Last occasion, your lordship directed to file the specific instruction from the BLRO.
Yes.
My lord,
It is there. Yes. It says disputed area belongs to private respondent.
my lord,
The disputed area belongs to private respondent. That is the report. Of the
It is-
total area of 4.27 acres, 0.12 acre is recorded in favor of the private respondent. 4.27 acres is Bandh, entirely
Lord,
government land under
eight-
Khotian 1. Of that portion, 0.12 acre is recorded in favor of private
my
respondent.
lord, no report is served upon me. My lord,
Serve a copy of the report on him.
and my lord, 804.
This
804
is
is
the situation. I will not interfere. Serve a copy of the report on him. Report filed on behalf of the respondent numbers 3 and 4 is taken on record. A copy of the report be served upon the learned advocate appearing for the petitioner. Full stop. List this matter for further consideration on March 12, 2026. Take instructions in the meantime.
এই আমাকে একটা কপি দাও।
Next.
Oh, shit. March 12th.
12th March.
I am for the petitioner. Pursuant to my lord direction, my lord, notice has been served, my lord, upon the private respondent. My lord, from the track report, it appears, my lord, he has received.
Affidavit of service?
My lord, the note, affidavit of service earlier, my lord, filed.
No.
There was no direction for filing affidavit of service, my lord, only service.
There is no direction will not do. For taking it on record, you should have affidavit.
Well, I am
Direction is required.
in course of this day, my lord, I shall.
Yes. What is your matter?
My lord, the petitioner is a owner and occupier of a plot of land In front of that, government land is situated, this canal land. Their private respondent has constructed the structure and obstructed my egress and ingress. This is the only complaint. No steps has yet been taken. Last representation, is that.
Yes, Mr. Bose.
Yes, my lord, I have spoken to my officers on all concerned. My lord, SDO irrigation, my lord, had asked for the land to be demarcated because under the law, the first step is to form an opinion of that being a public land. Now that was given to the concerned BLRO. Then, my lord, it stayed over there. I have spoken to them, my lord, on instructions I submit. It will take the BLRO 15 days of time from today to, my lord, demarcate and send a report to the SDO concerned for him to form an opinion and proceed in accordance with law. That is all. Yes.
It's a government land, then the follow-up action should be taken.
This writ petition, you file your affidavit of service.
Yes,
You will
yes,
not
but-
time the order. other
Yes,
day.
today, in course of this day.
I'm recording affidavit of
Yes,
service
yes.
filed in court today is taken.
Yes, my advocate
Please do
record.
it, otherwise it will again appear next day. I will respond all the orders.
No. What is it?
This writ petition alleges inaction on the part of the respondent state authorities in taking steps for removal of encroachment over government land stroke public land. Full stop. Learned advocate appeal.
12th February.
Respondent number 10.
10.
Respondent number 10 on February 12, 2026. Therefore, initially, learned advocate appearing for the petitioner invites the attention of this court to where is the relevant representation to the
Page
ST
46. Page 46.
to a representation dated
Yes.
made directly to the DM. Made inter alia to the district magistrate, Purbo Medinipur, and submits that despite such representation having been made almost 2 years back, no step now, more than 1 year back, more than almost more than 1 year back, no step has been taken by the respondent state authorities towards removal of the encroachment complained of in the said representation. Full stop. Paragraph. Mr. Bose, learned advocate appearing for the respondent state the relevant subdivisional magistrate, i.e. the respondent number 6, has already undertaken relevant inquiry and steps have been taken for spot verification and demarcation of the plots in question. Full stop. Paragraph. Since it is evident from the submissions made on behalf of the state respondents that the respondent number 6 has already taken steps towards initiation of appropriate proceedings for the purpose of public land common. Purpose will be served by keeping this writ petition pending. Full stop. Paragraph. Accordingly, the respondent number 6, i.e. the subdivisional officer, Eta Mogra Irrigation Subdivision, is directed to consider the petitioner's representation dated August 12, 2023, within brackets, annexure P7 at pages 45 to 48 thereof, bracket closed, and dispose of the same as expeditiously as possible, preferably within a period of 8 weeks from the date of communication of this order, full stop. It is clarified that if the said respondent finds that the petitioner's allegations are true and that there is unauthorized and that there is encroachment over government land stroke public land, the said authority shall initiate appropriate proceedings for removal of the encroachment and unauthorized occupation, under the relevant statute, including West Bengal Public Land, within bracket, eviction of unauthorized occupants, bracket closed, Act, 1962, full stop. It is needless to mention that the final decision for eviction stroke removal of encroachment shall be taken by the said authority in accordance with law, only upon affording an opportunity of hearing and of presenting their respective cases, to all interested parties, including the petitioner and the respondent number 10 herein, full stop. With the aforesaid observations, WPA 23139 of 2025 stands disposed of.
Time limit,
Full stop. Paragraph. If any such proceeding is initiated, if any such proceeding as aforesaid is initiated, the respondent number 5 shall endeavor to conclude the same in accordance with law, as expeditiously as possible, preferably within a period of 6 weeks. Respondent number 5 na kore 6 kore dibe. Respondent number 6, preferably within a period of 6 weeks from the date of initiation thereof.
Expeditious.
এটা এক জায়গায় লিখে রাখবেন, আমি লিখিয়ে দেবো ঠিক জায়গায়। Since it has been submitted that the subdivisional officer has already asked for verification and demarcation reports from the block land and land reforms officer, Nondigram-2 block, Nondigram-2 block, abar Nondigram, i.e. the respondent number 7, the said respondent shall take expeditious steps to forward such report to the respondent number 6 upon the verification and demarcation exercise being completed. Yes, next.
I'm for the petitioner lordship in this matter.
Yes, Didi. আজকে আমাদের এই ইউটিউবের ভদ্রলোক নেই। Next.
Lordship, the petitioner may submit lordship. The petitioner is having a plot of land, lordship. He had purchased the plot of land to start a eye hospital in Canning, your lordship. And in front of that hospital, there is a highway which belongs to the PWD, lordship. And he started construction of his eye hospital, lordship. In the meantime, what happened was the private respondents, they have constructed illegal construction on the Noyanjali, lordship, that beside the highway, there is a land, your lordship, which is known as Nanjoli. They have constructed there. Now, because of their construction, my whole thing has been obstructed, your lordship. Ingress and egress. I have made representations, your lordship. Nothing has happened till date.
Yes. I got a report from the police, but it is not exact. Because the BLR report is relevant, but BLR has not been made party. Because where it is contracted unauthorizedly, cassette, and particular which is related. On let me explain. It is the constitutional estate that an unauthorized person completely so asked upon because they ascertain that the plot of land where so Dr. Minor, kindly come to the page number 5, para number 9. Para number 9, last two line, right? Page number 5, para number 9, last two line. Has erected a concrete boundary on over his land. The total portion of my client plot has been obstructed and covered. And my
Lordship, what has happened is, no, your lordship, what has happened is, lordship will kindly come to page 41. Page 41, lordship. Lordship will kindly come to page 41. Previously, I was using that route, your lordship. But that land belonged to somebody, your lordship. So he has erected the wall. Lordship will kindly come to page 41.
On his own land. The petitioner just trying to avoid the civil jurisdiction and making this.
It's not that, your lordship. He has now.
Planning. Has not been made part. So without one sufficient, you will be added as part.
Nine and 10 years.
Carefully.
Lordship, item number 896, I am for the municipality, Lordship.
Indicating whether the land belongs to whether the PWD or the state. Yes, may I file the report, Lord? I'm sorry, Lord. Specifically, as indicated, in the first place, principles that this belongs to the government of West Bengal. Yes. 24%.
Island. Clean, bro. PWD.
On the last topic, notice of adjacent homeowners which have been served under section 10(1) of Highway Act. All the notices are. So,
Highway land. Hey, highway land. My lord, perhaps not, my lord. It is PWD land. Kindly. কোথায় হাইওয়ে কোথায়
Highway division, PWD.
PWD land. Yes, my lord, the report says, my lord, may I read, my lord?
Highway division, public works roads.
Public works road. Yes.
My lord.
Therefore, your lordships have the jurisdiction.
No.
Key known.
Highway
no, PWD.
Maintained by the public, maintained by the PWD.
Highway cannot be maintained by PWD.
It belongs to highway authority. It's in favor of district court under the government of West Bengal.
Highway authority is national highway.
Last two lines. Under the government of West Bengal.
Yes.
If that's so, copy the I like to draft the short explain. Why because of this.
Highway division.
PWD is a separate division.
Section 10(1) of Highway Act. Section 2, subsection 7 of 62 Act clearly
এটা কোনটা? But my lord, so far my instruction and my knowledge, because I also reside at that side, this is completely PWD road. Lord, therefore the South 24 Parganas division, the commissioner of South division will give the report. He is the correct man to say this. তাই না? ডিভিশন আছে না একটা? In another matter, perhaps your lordships directed and the report came. After that, the land was classified.
Shows that highway. And becomes highway worker. That is my
Highway.
is not national line. That is a national or state. Yes.
The বইটাতে 62 land.
Under section 3 of Highway Act, once it is notified, it will be considered as highway.
আমার তো এই আইনি আজকাল
If a notification is made under section 3, if a notification is made, then only it will be considered as highway. And these are the roads which were built. So far as I also reside here. So far as I know that, but that notification I do not. But the manner in which other notices were served, that shows that it's highway according to the.
Milord, as per 62 Act, Milord, the public land means any land belonging to or taken or leased by the state government, a local authority, a government company, or a corporation owned or controlled by the central or state government, and includes any land requisitions by or on behalf of the state government, but does not include a government road or a highway within the meaning of the Bengal Highways Act 1920.
Or any other law of the title bill. Or any other law of the title bill. Also, 25 here it is written, but 64 Act came later. So, yes.
But Milord, kindly direct the state to produce whether is there any notification or not. If there is any notification, then ওইটা কি না সাউথ ডিভিশন কি একটা আছে, একটা ডিভিশন আছে। না না না, ডিভিশন আছে, সাউথ ডিভিশন, তাহলে ডিএমকে
Other section of highway.
হ্যাঁ 3 মিনিটে তোমাদের রিপোর্টে কি
কে দিয়েছে 3?
Whoever is named, I'll check with them and sometime that.
Lordship, chat box is disabled. Lordship, Mir Onurujjaman on behalf of the municipality kindly be recorded. Chat box is disabled. Mir Onurujjaman for Rajput municipality.
There is a problem here. We don't have anybody who can work out.
Lordship. Mir Onurujjaman for Rajput municipality kindly be recorded, Lordship.
No, my lord.
Yes, চলুন call করুন দিদি call করুন
Item number 897 for the state. My application I'm paying for pass.
Lordship, the advocate on record for the petitioner is not in court due to some personal difficulty. I'm praying for not this week.
$899. $899 though. 5/6 of 2026. আমি মুভ করবো আমি রেডি সেটাই
Item number 900, my lord, on behalf of the petitioner. This is my affidavit of service, my lord. My lord, the petitioner made an application before the concerned authority, that is the collector as well as subdivisional officer, for the removal of unauthorized encroachment. The page number, my lord, 21 is my representation dated 16th December 2025. That has not been considered yet. So my lord, send it for consideration and consequential steps will be taken.
The report, my lord, the executive engineer, about 4 executive engineer. He asked for report from on 27th January 2026. Asked for report. The next page we will post it. On Kesal, LA. So we're waiting for the report.
But kindly dispose of this matter. Yes, my lord.
My lord will see that the 31 belongs to one point with father of the report. Now, my lord, we kindly see lab number 604 Pukur part. 604 Pukur part. My lord, every Pukur part also belongs to them. Now, my lord, kindly comes to the next portion. The next Khatian, that is page number 16. Nasimala. My lord, we kindly see 603 Pukur. Last one.
Charge number 603. That also belongs to Nasimala. This is petition number 1. Now I will kindly come to case number 7. Nasimala comes I will 604 Sukut part 606. Everything belongs to them.
My lord, I am not concerned with the private land. I am concerned with the public land which has been situated, lying or situated in front of my land. I am not concerned.
There is no issue of indication. Still that there is no indication.
My lord, kindly dispose and send to the authority, my lord. This is the collector.
What is that?
My lord, kindly see the paragraph number 4, my lord. This is my cause of action. Paragraph number 4, this is my cause of action, my lord.
But everything belongs to them, my lord. They are trying to enter.
No, my lord. This is not the civil right. Without investigation, how he determined that?
There is a land belongs to whatever the litigation department. Now, my lord, what? Now, my lord, the Sukut part, the brief, everything belongs to them, my lord. As far as the portion they have annexed. They have annexed nothing. That the land. Now, my lord, yes. Comes to paragraph number 3 and 4 once, my lord. Yes. My lord, let a report be filed, my lord. At least that report. Yes, sir. But the kind of activity point open for the SDO. Of course. But I think when
Yes, ma'am.
they have not annexed any document and my lord, they are not prepared to any. And my lord, they are not, they have at least a report may come from the body of my lord, because they have been they are playing for that and prime office for the revolution. Yes, sir. Because India in the paragraph number 3 and 4, they have made out the case of the that they are that I am occupying the land adjacent to their or something. I will record that according to that is not
December 16, my lord. No, my lord. 6th January 2026. Representation 16th December. Yes. Yes. No, my lord. No.
yes. So we have taken steps. No.
Chachol, Malda district, Chachol. Kindly keep the time. Any.
My lord, I am appearing for the petitioner in this matter, my lord. This is my affidavit of service. My lord, here, my lord, I have challenged the district magistrate's order, my lord. My lord, we have served, my lord. My lord, here, my lord, on the, my lord, I am the petitioner is the lawful owner, my lord. It is a Rayati land, my lord, but the government has declared it as vested, my lord. We have gone before the SDM has passed the order. Then we came before the High Court, my lord. The High Court has passed the order since, my lord, it was an appealable order. So High Court, my lord, directed to go before the DMs, my lord. My lord, so we approached the DM, my lord. Before that, one writ petition was filed before your lordship. Your lordship passed an order not to take any step and to pass the order by the DM, my lord. So DM has passed the order, my lord. It will be reflected from page 70, my lord, if your lordship kindly. My lord, since under section 7(1) of the, my lord, my lord, the order has been passed by the SDM, my lord. My lord. বইটা
কত কত বই নেই এখানে, বই নেই, বই নেই, কত সেকশন?
section 7.
পাবলিক ল্যান্ড।
I tender apology, my lord, for not having. An appeal from an order made under the Act shall lie to the Commissioner of the Division where the order is made by the Collector, and the Collector where the order is made by an officer specially appointed under subclause B. My lord. My lord, the Collector where the order is made by an officer specially appointed under yes, my lord. If preferred within 15 days, my lord, the order appeal against the decision of the Commissioner or the Collector as the case may be, or such appeal shall subject to the provisions of subsection 2 be final. My lord, if a magistrate enforce delivery of possession of such public land, if not a magistrate, apply to a magistrate or in Calcutta as defined. My lord. No, my lord, it is not. B. Elsewhere, the chief officer in charge of the revenue administration of the district and includes an additional district magistrate, a subdivisional magistrate, any executive magistrate specially appointed by the state. Malad. What? Mal. Mal. Then, your lordship, I will only, malad, in my most respectful submission, malad, I will only, malad, if your lordship kindly grants me liberty to move before the, malad, the commissioner, malad. All parties, malad, yes. Lordship rightly pointed. Your Lordship, I tender apology for not having the act, my lord. My lord. My lord. ভালোই হয়েছে। My lord. My lord, district magistrate's order is, my lord, on 16th December 2025, my lord. Page, my lord, 69A. It starts with page 70, my lord, if you lord. No, 69 AM, my lord. 69 is, my lord, is not legible, my lord. That's why, my lord, I have, my lord, given a type copy, my lord, of 69A. Deeply obliged. My lord, my lord. My lord. Deeply obliged. my lord, one indulgence, my lord. My lord, since my lord, the Beldanga municipality has already sent a notice, my lord, earlier notice. So, my lord, if your lordship can till the disposal of the my lord commissioners, my lord, order, this case, my lord, let there be a stay, my lord, my lord, deeply obliged. My lord. রেখে দিলি কেন? My lord, page 59, my lord, annexure P11. Yes, my lord, if your lordship kindly takes, my lord. My lord, paragraph 7 of your lordship's order, my lord, page 61. Since it appears from the documents handed up to the court that the petitioner's appeal is pending before the appellate authority, and since it has been submitted that the appellate authority has heard the petitioner's, my lord, my lord, my lord, my lord, as your lordship deem fit and proper. Deeply obliged. Deeply obliged. Extremely grateful. My lord, my lord. My lord, one thing, my lord, I think, my lord, the order of the DM is, my lord, it is 16th December, my lord. My lord, deeply obliged. Deeply obliged, my lord. Extremely grateful.
My lord, I am appealing on behalf of the state.
My lord, I am for the petitioner. My lord, this is my affidavit of filing. My lord, the unauthorized documents of government land. Petitioner made representation before the competent authority, that is 36.
32.
Page 32, my lord. My lord, I made representation to the district magistrate and subdivisional officer. My lord, I have annexed here some photographs, the private respondents. My lord, my lord.
My lord, of the same, my lord, already authority has acted upon, my lord, kindly see. My lord, yes, sir.
My lord, henceforth I will not file on this.
The basis of the same authority concerned has already taken steps.
Okay, Kadim.
You have directed the already Pradhan has already submitted report also.
My lord, Pradhan is not. Why? My lord, kindly indicate the respondent number 2 or 3. My lord, state authority will PLRO is not. My lord, that. My lord, kindly 2 or 3. Competent authority is that 2 or 3. 2 is the DM, 3 is the SDO. 3. Grateful to you, lords.
Well done for the petition. Yet the private respondent has encroached the land of irrigation and make a construction. Your lordship, kindly come to page 15. So. Plot number 146 is the government land. Lordship, I have annexed the record of right also. That is at page 15. Right. May I just check? May I just take that? One, only one. Everybody has received. Six, Sudarshan Das. Page 15. 1-5. Three, ma'am. Three. Subdivisional officer, Hon'ble. Lordship. I'm good.
And for the petitioner, my lord, let's have upon all the respondents. Application on the part of the respondent authority to removal of the unauthorized construction over the irrigation land, my lord. The petitioner made an objection, my lord. Petitioner made an objection, my lord. That is quite different, my lord. I have my own specific objection, my before the authority concerned, my lord.
For a moment, just my lord, my lord, for a moment, my lord, kindly come to page 33. I have annexed the latest record of rights, my lord. Page 33, that is plot number 593. The owner of the plot is the Paschim Bango Pokke Irrigation. Next page, my lord. Plot number 594, Paschim Bango Pokke Irrigation. Then, my lord, page 35, Paschim Bango Pokke Irrigation. That is the irrigation and water rights department. That means not a highway land or the PWD land. There is the adjacent land in between the PWD and the Yes, yes, I'm saying the construct the over the top, by the Peach Road was controlled by the PWD department, but the adjoining area, the owner of the irrigation and water is department. That is true, but
For removal of my I have served. Get close. Prior to that. Only notice to be served.
But 905, I'm appearing for the petition in this matter. But this is, I'm challenging the notice, in respect to that unauthorized occupations land, and also another proceeding, because this is not a government land, but I'm challenging the entire proceeding in itself. Now, this is my service, I have some. Private respondent, there is no private respondent, but this is my affidavit. Then, Lordship will kindly. Then, Lordship is taking only on Thursdays this matter. Then, then I have to, intimate him and come back, So next Thursday, yes, madam. Well, let it be appear in the position so that yes. Madam, may I, Mr. Joydeep Banerjee was appearing in other matter. May I confirm once, madam? Also, want to appear with you? Yes, sir. Yes, sir. Yeah.
I'm for the petition. I served upon all the respondents for the certificate.
And petition was filed 20th January 2020. Time is presentation made on 30th December and filed on 20th January 2020. 2019. Generally, whether the public land erection on after manual occupation act 1960 was applicable, or whether the rehabilitation of displaced persons and eviction of persons in unauthorized occupation of land act. Here, constructed a house for last 40 to 50 years. Private respondents. No hindrance. They are allegation made against the encroach the land of the petitioners. This is a
No,
big allegation.
not petitioners.
Signed.
That is the government land, not
Whatever
petitioners.
may be kindly map.
Question of
That is
the government land,
501,
the irrigation land.
constructed the 6-story building of my landed friend's land.
Yes, sir. That is my own property. If my property is within the government area, that should be demolished by law. My specific allegation is the illegal and unauthorized construction over the government land.
It is not there. As date is not there, but it is a premature. Within 90 days,
Yes, sir.
90 days, they find this application. There is
No, my lord, particular in this case, I am hurried. Particular in this case, my lord, only on this case, my lord, I am hurried due to construction is going on, as because this requisition was filed too much early date, my lord. Nothing more than that, my lord. But the allegation is specific, my lord, the construction of the irrigation land. The question. My lord.
Yes, all the time.
My lord, except 26, that is my personal difficulty. My lord.
This is my affidavit. Only more than 1 month. Previous with my friend's petition. My lord, after your lordship's direction, every matter I filed after 1 month. Yes. My lord, it's encroached by the one club and then one private respondent. My lord, it's a government land. They have encroached the pathway of the panchayat property. My lord, government land. And my lord, I have made representation to the
Paragraph 10, my lord, they have stated no such my demarcation and inquiry has been made, whether
No.
it is the government land or not.
My lord, that they will decide. And my lord, and consequential effect be given.
Instead of that one, in accordance with the, because
No, my lord.
applicable in this particular case.
No, my.
Yes, it's and another thing, my lord.
Hmm. My lord.
Grateful.
Another thing, no, is that if requirement of PLR or
My lord, always,
concern PLR,
my lord,
otherwise. Government.
Grateful.
Much okay.
For the petition. Well, the petitioner raised objection. Well, same order. March 5, March. Service is effective upon all this. All of get to.
Well, I'm for the 57. In old matter, this is the allegation of the unauthorized occupant or encroachment over the government road. This belongs to the irrigation department. If you lordship kindly take tabel to page 21 of my petition, in the year of 2009, 4th September 2009, my lord is got it for page 21. This is the address to the subdivision of the litigation. My lord, we lost the complaint. I have the original copy of the presentation. We lost the complaint with regard to the illegal encroachment over the irrigation department. 2009. Thereafter no steps was taken. Now they are going on construction. I filed an application under 133. The report, if you lost it, kindly take the page 32. Page 32, this is the report subdivision officer writing irrigation subdivision. Address to the subdivision officer Diamond Harbour. That in connection with the above site visit observed that one number of two-story buildings constructed in front of the petitioner Harindranath by the petitioner Deputy Lordship, plot number 4548, jail number such and such, and the size of two-story building, no other building is present just outside the above two-story building. The irrigation department did not give any permission for the construction of this building inside the QWD road. Even in they no step was taken. Then by the road. Last order I lost the complaint on 15th of January, page 35. All the authorities finally come to page 36 one. In the paragraph, first paragraph, that on 4th September 2009, I and my brother lodged complaint before you for taking steps for removal of illegal construction and the land belongs to the irrigation department at Digipar village, sent the main road starting from company to Pasmo in front of my landed property. Therefore, I filed an application under 133 and the order was passed. Upon you to take steps for removal of such equipment was the knowing jury. That is order.
This is the observation, I am not fixing the proceeding.
That there was no competition, there was no competition taken. Yes,
PWD. PWD.
And decide and by
Yes,
the
yes,
time of
okay.
the PWD without by the paragraph detail this is
Six, six will complete. Six and six and also. Six.
Litigation.
No, I'm going to sound the diagonal. block land and do the responsibility. This one is Mathura 2 block.
I am for the petitioner. I am for the petitioner. The affidavit of kindly see the page number 23, my lord. Page 23, my lord. Yes, my lord. The plot number, my lord, mentioned 214. My classifier is heart, my lords. There are others plot, my lords. We are the shop. We are the, my lord, the shop owner of the said heart, my lord. We are making the temporary gumti, my lords. But the private respondent number 7 and 8, my lord, filed a writ petition before the writ court, my lords, where, my lord, the writ court directed the PWD authority to consider the representation. My lord, while the PWD authority, my lord, consider the representation, my lord, they found that this road is belong to the collectorate. And, my lord, the SDO Kontai, my lord, taken a decision, my lords. My lord, kindly see the impugned order, my lords, at page 30. Page 38, my lord. Yes, my lord. Under section 3 and 4 of the West Bengal Public Land and Unauthorized Occupants Act. And thereafter, my lords, we prefer a statutory appeal under section 7, my lords, before the divisional engineer, my lord. My lord, still, my lord, it is pending, my lords. They are not fixed any date, my lord. My lord, kindly see the memo of appeal, my lord, at page 59. Within period, my lords, we prefer the appeal, my lord. Yes, my lord. This is a memo of appeal, and thereafter, my lords, we also file the stay application, page 69. That not taken up, my lord. They are not fixing any date, my lord.
In terms of this order, section 9 is appeal, section 7. An appeal from an order made under this act shall lie to the commissioner of the division where the order is made by the collector, and the collector where the order is made by an officer specially appointed under subclause B of clause 1 of section 2. Was there for a moment, my lord? Order was passed by the subdivision officer. He is the authority with count 2(1)(b). This is below the collector.
কি বলছে calculator কি বলছে?
The logical concept 1B. Secondly, any expense, especially appointed by the state government to perform smaller under one, the collector or the first authority specially appointed, then subdivision right to the collector. Here on the subdivision registered, subdivision right non-executive appointed. And so far it will be again. Revenue administration of the district and includes. So include the expression specially appointed by state government to perform all or any of the functions both with the executive with does not go with the chief officer in charge or additional only for the purpose of all the other officers are right to go to the commission. Right?
All the actions will be taken.
The logical concern, an appeal from an order made under this action lies with the commissioner of the division, where the order is made by the collector. Was there for a moment an appeal can be considered? Section 2, subsection 1. So 1A, not 1A. Now, another concern B. Lies with the collector, where the order is made by an officer recently appointed under some clause B of clause 1 of section 2 that was to clarify. The collector does not include for the purpose of inspection any officer especially appointed under some clause B of clause 1 of clause 2. Please read section 1B. Section 1B last portion. Is where the chief officer in charge of revenue administration of the state and includes an additional state-based subdivisional magistrate and to additional district magistrate, subdivisional magistrate, chief officer in charge of revenue of one class. The other class is any executive magistrate specially appointed by the state government. Now, any executive magistrate specially appointed government is the officer specially appointed under the clause of clause 2. Therefore, it is competent before the commission is rightly filed. The recovery after the I will go into the
Yes, ma'am. The disclosure is also, my lord, added to the order with the disclosure, ma'am. I already filed the stay application, ma'am.
Yeah, I am for the state. Right from the private one. But for the state, we are. We have to start. There is no clear to speak for execution here. All the clear to living. We have to give the order which is their passport operation. And finally, we have to not clear it with the and to appoint a competent officer. Or to appoint a
Now kindly see the paragraph number prayer D, my lord. My lord. And my lord, the appeal authority be directed to allow the petitioner to submit the claim as paid for an early date for disposal of the appeal. It take such consideration in the matter to be petitioner, the impugned order dated such and such. Public land. Seven and eight. In the meantime, my lord, kindly. No, what's the distributor detected, man? Yes, sir.
and I'm the 12 minute, I am for the petition. I'm for the private discussion. My condition is my lord, right? My lord. This is my evidence of service.
पिटिशनर के बोलते भी पिटिशनर के बोलते भी
What happened, my lord? The petitioner.
अरे आई एम द पिटिशनर বলুন আপনি তো পিটিশনার
I am the person as per the pasta granted by the common office. The petitioner made an exception or objection. The exception act. It is the exception part. Without having the appeal or the other, it is the order of the
Because the collector is to pass an order without considering the legal facts, and without considering the inquiry report. That is only illegal. That's true. Because what is the procedure? So first demarcate the land by the competent authority.
ফটোটা দেখ ফটোটা দেখ
And only one line I am giving you the order of the district subdivision order. That is at page 34. Page 35. Conclusion part. Order dated 5th December 2025. As per inquiry report of the block land and land resource officer Dalboni, it is found that Sadananda Das, respondent number 8, son of Ador Das, possesses 9 decimals of land of plot number so and so, which was awarded with partner. No other illegal occupancy or encroachment is found during inquiry. I have no grievance against the partner land, but there is a 12 decimal land that has not been mentioned. Can we see the record?
এটা দেখ ছবিটা দেখ হ্যাঁ
Not for, not for consideration of representation. That was passed without following the provision.
দেখান এটা দেখান মিডিয়া টেলিকাস্ট বন্ধ করে দিয়েছে সেটা যাতে না করে সেটা বলুন বন্ধ করে দিয়েছে আপনার বলুন
And after disposal of this, the private respondent completely obstructed the ingress and egress of.
Madam, for a moment, madam, for a moment, madam. They are preparing for consideration of the representation.
Oh.
Yes, representation.
Statutory লেখা আছে। Different area of land, plot is same, different portion, which has got patta. Respondent number 8. Subsection.
unauthorized occupation. By filing case, by filing case. And not that portion which is by filing unauthorized or might be of an appeal. I did following this step. The custody of the matter common is not however common. This order shall not be from approaching appropriate amendment under section 7 of the
ওটা বলে দিন, ওটা বলে দিন, ওটা বলে দিন। ওই ডিএমএটা বলে দেখুন।
And delay you can make an applicant liberty given to the petitioner. There is a provision. There is a provision. There is a provision.
Why different?
No. Yeah. And there is a provision. If after 15 days make an application. District magistrate because subdivisional officer passed an order. No, there is a
So the SBO has passed the order.
What if SDO has passed the order, then D.
SDO passed the order.
SDO passed the order.
No, it should be DM. Most probably 104. Is to perform all or any of the functions of the collector under this act. That is to be. Now we have kindly come to section 7, appeal and review. Explanation. In this section, collector does not include an officer specially appointed under subclause B of clause 1 of section 2.
SDO executive magistrate function যখন অর্ডারটা লিখে executive magistrate
না সে তো ঠিক আছে elsewhere the chief officer in charge of the revenue administration and includes an additional district magistrate, a subdivisional magistrate, and any executive magistrate is specially appointed yes. Only executive magistrate is specially appointed. Whether here is specially appointed or not, that I don't know. Act as a executive magistrate, subdivisional officer also act as a Other than. Yes. Any executive magistrate, especially any executive magistrate, then specially appointed by the state government. Here, subdivisional officer act as a subdivisional magistrate. Subdivisional officer act as a subdivisional magistrate. Oh, that's any executive magistrate, specially appointed. That does not include clause section 7. But in this section, collector does not include an officer specially appointed under subclause B.
It must be commission.
There is a commissioner.
Should be commission.
Commissioner. বুঝতে পারলে ওইখানে ওইটা
ওরা যখন when they write down the order ওরা নিচে যে স্ট্যাম্প থাকে ওটা
ঠিক আছে কিন্তু সাবডিভিশন ম্যাজিস্ট্রেট এখানে
Well, I'm for the petitioner.
ম্যাডাম এইটা
Well, the suffering an unauthorized construction in front of my land. Well, in the first round of litigation, I approached before this honorable court, well, and an order was passed. If your lordship kindly turns to page 43 once. 43, my lord. Well, where the competent authority was directed to decide my issue, and my lord, the court thought that the assistant engineer of the concerned highway was the competent authority. Subsequently, my lord, the concerned BLLR was put in a notice to come and demarcate. And after demarcation, my lord, it was found that land doesn't belong to the highway authority. If your lordship kindly turns page 66 once. Well, this is a letter written to me where the assistant engineer after being demarcated through the concerned BLLR, it is found that the land belongs to Jila Parishad. If your lordship kindly turns to page 66. This is the communication. 66 malad is the communication malad through which malad I was malad informed whether the learned advocate was informed regarding the demarcation by the assistant engineer that it was demarcated by the concerned BLN NRO and sketch map. No, malad. Then malad. No. Malad, since the land does not belong to malad the highway authority, the assistant engineer seizes his power to exercise the now malad it was communicated to the SDO since the land belongs to the subdivision. Now the game of passing the ball starts when the subdivisional magistrate, by way of another letter, forward the issue to the Jila Parishad. He is the competent authority to execute malad my grievance. Subsequently, on several occasions, I wrote to the subdivisional officer, see, this is the demarcation that has been taken place. Demarcation is detected, identified, but since the authority was something different, it was forwarded to you to initiate the further proceeding. That has not been done.
My instruction page 76 minus SDO forwarded a letter to the Nodia Jila Parishad. The land does not belong to the subdivisional. Belongs to the Jila Parishad.
Local authority.
Jila Parishad.
The secretary of the by the SDO and in response to this that madam it is of every
I have no knowledge about that letter, my lord.
My lord, may we get a copy of the report, my lord? And my lord, demarcation, my lord, land is identified by, if your lordship can. Page 67 and 68 is the identification.
Yeah, they have purchased the property in the year 2020. Alert, the land is our global land, not the house or the land.
Sketch map, photographs, identification, demarcation, my lord, quantity of identification, everything. It is there in the record I have given. Page 70.
Government, I constructed there. And land is
পারচেসটা কি করে করেছিস? পারচেস করেছিস কি করে? Six is the SDU. Even after demarcation. Malad, this is my last communication at Malad, page 126.
Well, only one inland just may we get
Cause of action is not already started. Actually, the internal cause of action started. When that report says
129 delivered on 11/11/2025. 122. This is delivered. ওই কপির কথা বলছি হ্যাঁ পাঠিয়ে দিয়েছি বলছি গ্রেট
Milord, I am for the petitioner. This is my
objection is petition filed by suppressing the material fact. A title suit is pending to the same plot of land before the non-exhaustive court. And petitioner filed a written statement to also title suit. However, that fact has not been mentioned there. Or it should be dismissed from court.
I am filing for removal of unauthorized encroachment from the government land, not from the royalty land. And that's why I have not disclosed anything. Self-same plot, there is a big plot, big land, 107 acres. Out of that, only 16 acres. Suppose. So what? What is the remedy? What is? My no allegation against. How many? Oh, I am only made allegation in respect of unauthorized encroachment of government land. What my learned friend is saying. So what?
Has not been mentioned.
So what? You have constructed a boundary wall, you have encroached the government land, and I have no right to say anything. I have lodged a complaint to the appropriate authority. Will not kindly see page 16. I have annexed the record of rights, wherefrom it shows that the land belongs to the government. That is at, kindly come to page 14. Record of rights. What my learned friend is trying to mislead the court.
Page 5, kindly see 2011, page 5.
Yes, already petition.
Yes. Yes. Page 14, I have annexed the record of rights. Huh? Correct. Can I state the copy? And she ruled in the plain. But that is in respondent number 4, Miller. Block land, no. Respondent number 5.
He has to serve copy upon the BLN or anyone.
I have served upon the government. I have already served upon the government, please. No. To the respondent number 5.
Respondent number 5.
Grateful.
My lord, I am appear on behalf of the petitioner. My lord, petitioner made a representation page 15 and 16. The private respondent number 7, illegal encroachment on the public footpath, resulting of the blockage of ingress of the petitioner. My lord, yes, my lord. Every service. My humble submission, my lord, the respondent number 3, subdivision officer Baripur, to consider my representation in terms of the section 4 and 5 of the Unoccupied Act, my lord. Page 15 and 16, my complaint, my lord. page 14 of the picture of the photocopy of the encroachment, my lord, page 14 in my writ petition, my lord. Page, my lord, my lord, delivered, my lord, tag depot, my my lord, consider my representation in accordance with the my state explanation appear, my lord, every sir, my my lord. My lord, appear on 26, my lord. I mean, get out. My lord. My lord. 26. My lord, again I start with the establishment and my lord. My lord. My lord. No, my lord. But in this matter, if my lord. My lord. On the point, your lordship, right? My lord. But if I may submit, your lordship, as far as your lordship, if I may then indicate where my matter can be distinguished, your lordship. Your lordship, in this case, where the facts are, I just briefly want to recapitulate that I had initially been assessed, but my income was increased substantially and a tax demand of about 4.7 crores was raised on me.
But in the meantime, this is for assessment year 17-18. Thereafter, Your Lordship, for the assessment year 19-20, my lord, a 143(1) notice is issued. This is not a 245 notice, but 145 intimation where they are processing my return. In the processing of my return, Your Lordship, they make an adjustment of the entire demand pending for the assessment. But I have made an application, my lord. This is subsequent, but an application is there. But my lord, nonetheless, Your Lordship, the department, even if it wants to make an adjustment, my lord, my appeal is pending. Your Lordship, the department needs to give me some kind of an intimation for recovery. And plus, even if it wants to make the recovery, it has to make it in accordance with law. And there are decisions in my favor, but whether or not I am treated as an assessee in default, they cannot still recover beyond 20%. And if they want to recover beyond 20%, then Your Lordship, they are supposed to say as to why my case falls under any of the exceptions. In fact, Your Lordship, there are decisions of the Honorable Delhi High Court which have said that this requirement of 20%, as my lord, in fact, it had also fallen from my lords on the previous day, that this 20% is pursuant to an office memoranda. It is a guideline. The power granted under section 220 subsection 6 is much wider and needs to be exercised judiciously. And that office memorandum is only a guideline. Nonetheless, Your Lordship, even if we take that office memoranda, there are decisions of this Honorable High Court, of the Honorable Delhi High Court, as well as the Bombay High Court, which says that if you're adjusting beyond 20%, you need to give reasons. In this case, Your Lordship, initially the department adjusted 100%. As when they made the adjustment from the assessment in 1920, the refund, without 245 notice, 100% was adjusted. Thereafter, 154 proceedings were initiated. My demand was substantially increased from 4.7 crores to 10.82 crores. Thereafter, Your Lordship, for the first time, for the assessment year 23-24, I am issued a notice under section 245. They saying that they want to adjust my refund. Now, in response to this, I filed two responses. First, Your Lordship, I say that you have already adjusted 20%. Kindly do not adjust anymore and refund the excess to me. And simultaneously, on the same date, I also file an application saying that please do not adjust any further. And I did that. Absolutely. And then, Your Lordship, what is the conduct thereafter? But if I may, but if I may just conclude, my lord, just to factually, my lord, just to summarize. But I make that application on the first occasion for assessment year 23-24. And what is the reaction of the department? They pass a non-speaking order wherein they adjust 41 lakhs. So they bring their adjustment from 44% to almost 50%. Thereafter, my lord, they do the same exercise for assessment at 24-25, where I'm entitled to a refund of almost 7-8 crores. My lord, or more than that, what the department does is again issues a notice. My lord, I again file two objections. One is, please give me more than 20%, and secondly, do not make any further adjustment. They again adjust 5 crores. So, my lord, they're effectively, my lord, they've come to almost 10.86 crores. And even in November, after filing the writ petition, they've made further adjustments. But in this case, in my case, Your Lordship, I am constantly making representations to the department, relying on case laws of this Honorable High Court. Not once have they considered it. They've passed non-speaking orders and have made adjustments. And my lord, even if I may indicate one more fact, Your Lordship, on the previous occasion it had fallen from my learned friend, that Your Lordship, in case the CIT appeals is directed to pass the order expeditiously. Because, Your Lordship, I have participated before CIT appeals. I filed copies of my written submissions and also, my lord, the acknowledgement showing all the documents filed, hearing notices, everything. But even if I, today, my lord, assuming the worst, the order is decided against me by CIT appeals, even if I am to move the tribunal, Your Lordship, the tribunal is also under the statute bound to grant me a stay on deposit of 20%. In this case, Your Lordship, 20%, much more than that. Now, my lord, today we are standing on more than 90% on adjustment, 99%, my lord, because in November they've again made adjustments, almost, my lord, 98, 99%, and they will keep making adjustments because, Your Lordship, they will keep charging me interest. Interest is constantly rolling. So they will keep adjusting interest. And as per the office memoranda, they're supposed to dispose of my stay in 7 days. Irrespective, Your Lordship, my representations are there before the department.
I know. That only that, my lord, cited northern cold. Maybe I forgot. I'm finding it.
And I'll just examine the decision, Your Lordship, but I'll just want to see whether, my lord, in this case, they've passed any speaking orders for 245. And because, my lord, in this case, in my case, Your Lordship, I'll come back and I'll consider, because my, to what my memory serves me correct, Your Lordship, the matter even before the Honorable Supreme Court.
At this moment, I will look for that Rajasthan.
Gujarat High Court.
Gujarat. My lord, I have seen something.
Absolutely. And even I'll consider that. I'll look for it. Since it's fallen from my lords, I'll look for it. Understood. But that was, I think, the matter which my lord had earlier said, is that there is a matter on the original side where Mr. Majum. Okay. Okay.
Yesterday was.
I'll ask Mr. Kejriwal, Soumya Kejriwal, I'll ask. And then I'll do one thing, if subject to, as my lord deems fit, let me also consider these two cases, because my all the decisions that I wanted to rely on, I've already placed. Yes, Your Lordship. Yes, sir. Because, Your Lordship, another point, as I've been harping, my lord, that the initial adjustment itself was invalid, because 143(1) is not the provision to make an adjustment. But the decisions, my lord, the decisions on that fact that for making an adjustment, it has to be through 245 mechanism and on. But even for exercising the power, today if I want to make a recovery, it has to be through the mechanism permitted under law. So 143(1) is not the mechanism permitted under law for them to make an adjustment. My lord, absolutely. My lord. My lord. My lord. But I'll also see whether my case is distinguishable on the fact that I made representations. My lord. My lord. Absolutely. Absolutely. I'll consider. My lord. My lord. Absolutely, my lord.
And my lord, northern coalfield that order was challenged before the Supreme Court refused to.
But the Supreme Court, from what I remember, because Mr. Kejriwal told me earlier, I think it was this one only, that the Honorable Supreme Court said that the decision is to be limited to the facts of this case. So the Supreme Court very categorically limited itself to northern coalfields only and not to my lord passing on.
My lord, I am for the petitioner. I am led by Advocate Kanavia. I am praying for nothing.
But it takes some time only. I can take. Okay. Nothing will happen. Only. No, it takes some time, my lord. My lord can fix the matter on a particular date. No, it will take some time. So item number 10. 10. 10. যা খুশি আমার রোজই আসছে আমি এনি ডে আই ডোন্ট I have received the copies or as per the blocking of electronic ledger, negative blocking.
Then I'm requesting the Chakraborty might not be.
I have no problem on any date, man. আমার কিছু না হলো আসতে হবেই
Chittopriya Ghosh. I am praying for nothing.
My lord, I am praying for nothing. I am for the formal response. Direction.
Well, I am for the petitioner, my lord. Well, in this matter, my lord, I have some urgency because of the 18 and 19. This my lord. On the last occasion, my lord, 271E, we are challenging the order passed under section 271E and 271D. Now, there is a violation of 269SS and 269T. By a writ petition, both the writ petition, the period is same. The assessment order passed in 2009. Satisfaction matter, my lord, after more than 5.5 years, they have issued the penalty notice. Well, I have submitted the one. Yes, ma'am. Well, I have some urgency even in this matter because yes, ma'am. Yes. I am for the petitioner, my lord.
55 and 26, my lord.
Huh? Question.
Five. 37, my lord.
92, Your Lordship, I'm appearing in the matter. On this matter, Your Lordship, we've challenged the 148 proceedings for the assessment year 17-18. But actually, when the primary grievance of the petitioner is, Your Lordship, there was search and seizure proceedings at my premises. But various assessment years were considered, including the assessment year before my lords, where the department had accepted my submissions in the course of the assessment. Your Lordship, on the same allegation, 263 proceedings were conducted against me. While 263 proceedings were set aside on the admission of the department in the other years before the tribunal that there was no incriminating material against me, Your Lordship. And 263 in this case was basically in the garb of a review that was sought to be done by the Commissioner of Income Tax. So it was squashed by the ITAT. Your Lordship, now on the very same issue, the department is conducting reassessment proceedings, and my lord, the information is being uploaded by the assessing officer himself on the portal, and it is the same information on the basis of which assessment was being done. So, my lord, in this particular case, my humble submission is that my lord, the entire reassessment proceedings is in the excess of fishing and roving inquiry, and my lord, the same issue is being examined over and over again without there being any new tangible material in the possession of the department. Change of opinion, categorically change of opinion, no new information, Your Lordship, there is no information at all. And even if that is considered as information, the tribunal has held that that is not an adverse incriminating material. But Mr. Arik Datta, I believe, is opposed. But kindly give a date, I can inform, learn it from. Why not? My lord. My lord.
That will be better on a weekend. Point it out the court, will take only 5 minutes time. And some of the matters are covered by the some.
Your Lordship.
Yes.
Although, if I may say, indicate, my lord, that I'm also guilty of arguing for a good length of time at all in the matters. But a friend of mine who is a counsel practicing in UK, in London, Your Lordship, he told me in each matter, my lord, the matter as in the time allocated is fixed. So the counsels have to argue within that time frame only. My lord.
Very restrictions become very difficult for it. My lord, one thing we can do, my lord, for some of the matters. But my lord, for some people who on and on that also that time. One is to understand that defines the understand that we of this type or that type. Then in that case, we have to according to that is how that is for craft.
Yes, my lord.
You go on delegating and that my lord will have yes, but I have time to indicate that that's enough, that's enough. But if somebody doesn't have it, just can't get away.
But my there, my, if I may, my, if subject to what my lord deems, man, I don't want to be, but I will always try and say my matter is a short matter. That is. My lord. I am grateful, Your Lordship.
This is for extension of interim order, Your Lordship, this.
Planning gets parallel comments from there, but March ending, they are very busy.
This extension. Same prayer, Your Lordship.
Same prayer, my lord. The transfer brief, I've got the brief just today, but both me and Mr. Mitra was doing.
Banti da Mikey joy.
Mikey joy. For which 2 weeks in the
Same prayer, Your Lordship.
2 and 3. Same matter.
Do not be silent.
Kindly adjourn the matter for 15 days. I think by 15 days.
Yes, we are close to reaching a settlement. They said 82,000, I said 34. We're settling somewhere in the early 40s. So,
Well, subject to Lordship's approval, your Lordship's 12th.
12th March, you want or another week? 19th. 12th. 12th, my lord. 19th, we'll have to work out a settlement also.
the application, my lord. What had happened was, my lord was seized of the matter. They issued a notice for recovery. It's one of those matters.
Yes, my lord.
So kindly have it on.
But we are seeking, my lord, for extension of time, my lord, to file the affidavit of jurisdictional lawsuit. Kindly grants to this time, within which time I can file the affidavit of.
My lord, kindly.
My lord, yes, my lord, they already, my lord, in earlier matter, similar matter, my lord, granted them liberty to file an application.
Well, in this case, my lord, what I have gauged is that the 15. Well, it is in the process. It is in the process, my lord. Kindly so have it, my lord. Kindly have it in on Wednesday or Thursday of the coming week. By that time, we would have completed all formalities and served the other side also. Yes.
My lord is keeping it next week.
Wednesday. Wednesday, if it comes to my lord.
Yes.
25th. Grateful.
Lordship, the affidavit of service, Lordship, similar to item number 5, Lordship, same impugned order. Lordship, the grounds. Lordship, we will also be filing a can, Lordship, because the demand notice.
Lord, I have gone through the affidavit of service, my lord. Actually, they have served the copy upon the Ministry of Law and Justice. Now, with regarding to the service upon the respondent number 2 and 3, I can see from their affidavit service they send one email, but there is no service to the upon the respondent number 2 and 3 custom. Therefore, my lord, department saying that. Later, my lord, even not there.
No, it has been served. A soft copy has been served, Lordship. Will serve a physical copy.
Unless they get the hard copy, my lord, it's very difficult for them, my lord, to indicate.
Lordship. 25th. Lordship is not passing an order, then may I take the affidavit?
My lord, I appear on behalf of the petitioner, my lord. This is a similar matter. My lord, now a demand. My lord, we have served upon Mr. Kundalia's office directly, the physical copy. My lord, the challenge is there was a raid that was conducted in the year 2021. Thereafter, my lord, they were supposed to give us show cause notice under section 28. Yes. My lord, 2021, the raid was conducted. Thereafter, the Panchnama and everything was executed. Thereafter, investigation commenced. Thereafter, they gave a show cause notice under section 28(4) and section 124 of the Customs Act beyond the limitation period which is prescribed under section 28(bb) of the Customs Act. Now, this is the first point we have taken. That is why the show cause notice itself is beyond the statutory period and hence bad. The other point that we have also shown is we had given a reply to the show cause notice and we had asked for certain documents that they were relying upon, which is also has been relied upon in the impugned order, but was not disclosed to us. Only they said that RUD documents would be provided to you, nothing else would be. So that is why we had said that all those other documents also were required by us so that we can conduct the hearing. A third was that certain individual statements were highly relied upon in the impugned order, and we asked for a cross-examination of those witnesses, but that was also disallowed. And there's another point, my lord, they have also relied upon certain electronic documents, but had provided a fraudulent 65B certificate, which is appearing, the 65B certificate is not akin to what the section says, how it is supposed to be, and it is dehodes the Evidence Act. Well, these are the main points we are banking on. And that is why we had asked for a similar order that was passed in, my lord, this matter, my lord Zakir Khan, by my lord. He has a copy. I just now, after this order was passed, my lord, now we have received fresh demand notice. We have received notice of demand for payment of dues. They are asking for recovery of the and imposed penalty thereafter.
Well, on the first point, with regard to the delayed show cause notice that has he taken that point in his reply?
Yes, my lord.
How it has been dealt in the order that he needs to show. If he can show that he has taken that point and how it has been dealt with in the order in original, then I will seek time to create a clarification to whether there's a document there which has got extension.
If no,
no man. Yes. No, my lord. Here, there is a statutory. You can take an extension from the higher. Now, thing is, if he has taken that point, in show cause, they ought to have shown it to him that this is the extension. That may be an issue. One. Two is, if he has not taken that point before the show cause at the time of adjudication, then I have to now go and take instruction whether that document is there or not. Then it's not incumbent on them to give it to them. That extension is not incumbent on the department to give it to them unless sought for.
My lord, if my lord kindly sees the second reply, page 1852, will be volume 13. Yes. 1852.
1852 तो एक था.
My lord, I think my page number is missing.
Yes, sure. Now it's really easy for him to carry everything on the this. I have to carry everything. Now you should also understand that.
My lord, I'm just taking it.
Till then, you find out from the second point, if I have relied upon documents as a one in the list of time past year, and I have given those documents. If he can show that I have used other documents other than relied upon documents to pass this order, only then he has the right to see those documents. So these two things he needs to show for. He himself admits in his petition that these are documents which are other than the relied upon documents. Those documents have not been used for the purpose of passing the order. So unless he satisfied my lord on these two,
My lord, if my lord, kindly takes up the recording in the judgment itself. It is page number, if para number 137 of the impugned order, it will be in
1600.
my lord, the writ petition is not opening in my file. That is why I'm having a little difficulty. My lord, I also, as because it's voluminous, it's not opening at this point of time. That is why I'm having a little difficulty.
My lord, takes it this on second one because something similar is there on second. My lord, so my lord keeps it on whichever day.
Lordship, similar matter, similar impugned order, your lordship. Though we have not been served with the claim like penalty documents yet. Demand notice, sorry. Demand notice we have not been served with. The circumstances are a little bit different. We have not reached that stage yet. Everything else is still the same. There is a delay of 8 months, 9 days. Lordship, in our case also there is a delay of 8 months, 9 days. Yes, your lordship. Your lordship gives me 1 day. I'll come back, your lordship, before your lordship. I'll need a day, just a day, lordship.
In that case,
Lordship gives it on the 25th, the same day. All the matters are.
My writ petition, Lordship. Lordship, my leader is appearing online.
I'm appearing for the petitioner. The arguments have already been made by Mr. Mojumdar. I shall not dare to improve upon them, but it does fall to me to answer your lordship's inquiry on the last date of hearing as to whether I had urged for cross-examination at all before the respondent authorities. Now, indeed, the answer turns out to be that I had not. However, I do share common grounds otherwise with the rest of the petitioners. If I may submit very summarily as to what my points are, I will still be relying upon the fact that the show cause notice is void ab initio under section 28BB of the Customs Act, which mandates completion of inquiry within 2 years from its initiation. Now here the search on October 18, 2021 commenced with the timer. Now this is extendable, of course, by 1 year with recorded and clearly communicated reasons. Now the show cause notice in our case was issued on June 27, 2024. Therefore, it exceeds this period by over absent any extension and or recorded communication of such extension. None of this was communicated to us. Now, non-compliance to the statutory period prescribed here has to be fatal to the respondent's case. This has been proven multiple times in previous judgments. One of the judgments submitted by my learned senior was 2016 for SCC 769. My learned advocate on record will hand over a copy. This judgment had remarked, the Supreme Court had remarked that a valuable right has accrued in the favor of the assessee when the period of limitation expires. If the commissioner or anyone or the respondent authorities is permitted to grant the extension even after the expiry of the original period of limitation prescribed under the Act expires, then it will give him the right to exercise such power at any point of time. Now, even after the last accruable date of assessment. This is in paragraph 23, Your Lordship of the judgment. This has already been submitted by Mr. Majumdar. Now, that is but one part of my argument. Compounding this, my case is a bit peculiar in the sense that the adjudication flouts natural justice principles codified under section 122A of the Customs Act. Now, this has been brought into invocation because I have been denied personal hearings mandated by their own master circular, which is dated 10th March 2017. Specifically here, paragraph 14.3, I have annexed this in P5. Your Lordship, this is found in page number 1907, to be exact. This mandates 3 personal hearings. Compared to all the other petitions, other arguments made by the petitioners, I have not been even recorded under any statements. My statements have not been taken, so the question of cross-examination also did not arise. I was not served the notice that a proceeding was going on. This is the first time I'm able to raise these arguments, and that too before a writ court. So all I am harping on are principles of natural justice. I cannot and should not go into the merits of the matter, but it is my
you were not served with a notice, meaning you were not even served with a show cause notice.
I was served with a show cause notice for the first time, but the second time an irrelevant show cause notice has been taken into consideration.
So show cause notice, n number of show cause notices were issued.
One. And he has stated so in paragraph 13 at page 11.
What do you mean by show cause notice was served for the first time and then second time? How many times do you want to show cause?
There are 2 show cause notices. One of them I was not a notice.
Second show cause notice.
One of them I was not a noticee. This is the one 16th of October 2024. I was not a noticee.
Which page?
Number 1817. 1817. And if your lordship comes to page 1889, your lordship will see the list.
Volume 13, volume 30.
1889.
Terra number, last volume. Terra.
This is the last show cause notice. The notices are listed, your lordship, 1 through 24. I am not there. Jitendra Kumar, I am not there.
So show cause notice was not served upon you at all?
No.
Then how did you come to know about this?
Your lordship, this is regarding the second show cause notice. The first show cause notice was served upon me. This was in 27/6/2024. This is the first one.
Why was there a requirement to issue a second show cause notice?
Your lordship, they have considered both the show cause notices and formed a common impugned order. That is the difficulty, your lordship. I was coming to that point. The impugned order relies on this second show cause notice, and whatever material is gleaned from there should technically not be applicable to me because it includes.
That by itself will not make the order bad, because 2 show cause notices have been considered and 2 show cause notices had been issued to 2 different persons for So far as your case is concerned, is it your case that the charges that were leveled against different person in different show cause notice were also adjudicated as being charges leveled against you?
No, they were adjudicated analogously.
There may be two show cause notices addressed to two people.
Yes.
One show cause notice alleges charge X and Y. Another show cause notice alleges charge A and B. Charge
Yes.
X and Y is in respect of person P. Charge A and B is in respect of person Q. A is the adjudication in respect of A is in respect of charge X and Y only. You cannot fault the order till such time you can show that the adjudication in respect of A is in respect of charge X, Y, and P and Q.
Your Lordship, it is.
Proposed notices have been considered by a common adjudication order that will not make the order bad.
But that is certainly not my only point, Your Lordship. I was already harping on.
Tell your best point.
My best point, Your Lordship, is first of all, this is prescribed by 28 BB. It is a violation. I have already moved across that point. I hope I have been able to impress Your Lordship that
28 BB means? What is that?
The Customs Act.
of the Customs Act, Your Lordship,
Yes.
it mandates that the inquiry is to be completed within 2 years of its initiation. The initiation here, the search and seizure, was conducted on October 18, 2021. Now this commences the timer. Now this is extendable with clear and communicated reasons. If this is communicated to us, that is only extendable, but no such extension has been done. The show cause notice was issued on June 27, 2024. Therefore, it exceeds this limit by over 8 months.
Very well. So it has overshot the period.
Correct.
Yes, yes, that is one of my points. The other half was that the opportunity of being heard under Section 122A of the Customs Act includes certainly the chance to submit evidence, at least rebut evidence, absent which the proceedings cannot be. 2A, Your Lordship, 122A.
122.
A of the Customs Act. The adjudicating authority shall, in any proceeding under this chapter or any provision of this act, give an opportunity of being heard to a party in a proceeding if the party so desires. Now, my statements were not taken at all. If the list of statements are to be perused in the impugned order, my
wasn't heard, Mr. Dey.
Order to that extent, I have to take specific instruction whether he was, as he has submitted, whether he was at all given any chance of hearing or not at all given chance of hearing.
Wherein the adjudication order has is the discussion about you, I mean your client.
Your Lordship, only to the point that I'll bring Your Lordship to the point. Your Lordship, page 1255. Paragraph 32, Your Lordship. Statement is recorded in paragraph 32.
One two five five. 1255.
Paragraph 32, Your Lordship. It is said here multiple summonses were issued to the DRI by the DRI to Sri Jitender at all his known addresses. However, Sri Jitender kept evading investigation. I have to challenge this statement, Your Lordship, because I have not received any summons. The burden, I suppose, falls on the respondent authorities that they have served correctly.
Well, prima facie, it doesn't appear that you were not heard at all.
But my statements were not recorded at all.
The statements were recorded, it will appear from paragraph 32 itself.
Your Lordship, the statements that were recorded, I'll bring your Lordship to the statement that is being recorded. This is,
It says statement of such and such was recorded before senior intelligence officers.
your Lordship, I
108.
was illegally arrested on the 6th. I was illegally arrested on the 6th of November 2023. I was detained. I was made to sign blank papers
Very
of
well,
court.
but I'll have to give them an opportunity to file an opposition to this.
Absolutely, your Lordship. I cannot deny that. Of course, your Lordship.
Let them file their opposition.
Other slight points I'd like to make, if I'm making the submissions, if I may finish the other points. One of them is in common ground with the submission made by my learned advocate on the previous matter. The section 65B certificates of the documents that have been seized are in question. Your Lordship,
So
any
your points are: one, limitation; two,
Yes.
violation of principles of natural justice, that you were not given opportunity of personal hearing.
Yes.
And what else?
And your Lordship, that the impugned order relies on an unrelated show cause notice, which your Lordship is not acquiescing with me on this point. But the second show cause notice also implicates me by virtue of their statements recorded there.
Very well.
Which-
I'll record this. I'll grant them opportunity to file affidavit in opposition.
Obliged, your Lordship.
This writ petition.
They are all, Lordship.
He has vanished.
Your Lordship, I'm here.
Yes. So 3 points were there.
Yes.
Any other point? Yes.
Your Lordship, the section 65B.
I've got it. I've got it. It is further submitted that although the petitioner was served with one show cause notice, Chalo, next. Mr. Dale, an advocate appearing for the petition, appearing for the respondent customs.
Your Lordship, I think the court has muted me. I'm unable to hear what is happening.
On affidavit, full stop. In such view of the matter, let affidavit in opposition to the writ petition be filed within 4 weeks from date, full stop. Affidavit in reply thereto, comma, if any, be filed within
2 to 3 weeks thereafter, Lordship.
2 weeks thereafter, full stop. List this matter for hearing immediately after expiry of the time fixed for exchange of affidavits.
Oblige, Your Lordship.
Grateful, Lordship.
So 4 points were there. I've recorded 4.
Yes, Your Lordship. The court shut me off during the order dictation process, so I was not able to follow.
It is good. Otherwise, your 4th point would have vanished.
Oblige.
Grateful, Lordship.
I'm for the government side.
Yes. Ms. Mukherjee is busy with elections. I was informed in another matter last.
My lord, submission were made. May I submit, my lord?
Yes, you can also submit.
A submission were made made on behalf of revenue matter. I'm just repeating for my lord's convenience.
No, but whatever has been made is all right.
Yes.
If you have to make further submissions, you make that.
No, my lord. Just I can repeat. Everything was done, my lord. Everything was done.
She said she will take some more time.
My lord,
That
this
is what was
matter,
submission. That is what was submitted.
Your Lordship, my learned friend had taken a point which was not raised in the show cause. However, Your Lordship, I have addressed that by Your Lordship, I had handed over a list of date. If Your Lordship kindly takes that, Your Lordship.
Yes.
Your Lordship, the point which my learned friend made, she had referred to page 181, which is volume 2, Your Lordship.
Page 181.
181, Your Lordship, she had read point number 7, Your Lordship, Roman 7.
Yes.
Your Lordship, I would place the entire point, Your Lordship. The goods declaration as per invoice cum packing list was energy drink. Under RITC number is given. He had nothing to say about the goods since he had not seen the goods earlier. However, upon examination, there is a contradiction with the declared items for which the exporter can explain as the exporter is directly related to the goods. And Your Lordship, Your Lordship, then Your Lordship had asked me to show Your Lordship the relevant statement. And Your Lordship, page 153 onwards, his statement is there. And Your Lordship would remember, Your Lordship had identified at page 156, point number 10, that when he was shown the goods, Your Lordship, during examination, he was shown the MRP, and then he said, yes, the MRP is more. He did not know beforehand. And Your Lordship, to demonstrate that, Your Lordship, I am referring to that list of date. Your Lordship, the shipping bill, Your Lordship would find the third entry in the list of date. 23rd January 2024. This is the date of filing of the shipping bill. It also appears in the show cause notice at page 62, Your Lordship. And Your Lordship, the day when the goods arrive at the custom freight station is page 62, Your Lordship. Your Lordship, in the show cause, the list of shipping bills and the date is given at page 62, Your Lordship. In the table form, Your Lordship. And Your Lordship, from the statements, Your Lordship, which is at page 72 and 74, part of the show cause only, Your Lordship. Your Lordship, the goods were transported to the custom freight station only on 24th. So, and that too in a container, Your Lordship. So petitioner had no occasion to see the goods. That has been his consistent stand. That is not even disputed in the show cause or in the order in adjudication. Now, Your Lordship, quickly I will take Your Lordship to the order in original. Why the order was, Your Lordship, the date. That Your Lordship, towards the end, Your Lordship, he admitted that he had transported the goods in container to the custom container freight station Transworld terminal on 24th January, Your Lordship. I wanted to show this date, that the goods are coming in the custom station only on 24th, whereas the shipping bill has already been filed on 23rd. The petitioner, as a custom broker, had no occasion to see the goods, Your Lordship. And Your Lordship, when his state And Your Lordship, the statement which is being referred to at page 181 was taken only on 20th February 2024. The statement is at page 152 to 157. From the question 10, Your Lordship, the answer to question 10, Your Lordship, it is evident that he was shown the bottle and he was asked if the price discrepancy is there. He said, yes, it is there. That does not mean that he knew it on the date when he filed the shipping bill on 23rd, before the goods actually arrived at the custom freight station, Your Lordship. That too in a container, Your Lordship.
My lord, a custom broker who acts on behalf of custom department ought to act more diligently, my lord. Just after my friend submitted in the point number 8 of his voluntary statement, my lord, he has admitted that he has scrutinized all the documents, my page number 181. Just after that point, my lord, point number 8.
Your
181,
181, last point, Your Lordship. This I had shown from the statement that he was shown the goods, and then he said he has seen the website of Hamdard brand minutely, and in his opinion, the unit price declared is overvalued and too high and unreasonable. Your Lordship, apropos to this, Your Lordship had asked me to show the actual statement, which is at page 156. The statement shows that he was shown the website and he was asked this question. And this answer is given on 20th February. He has already filed the shipping bill on 23rd January, Your Lordship. Your Lordship, this is, Your Lordship, that's why, Your Lordship, this is not the scope of the writ. This was raised from the bar. It is not there in the impugned order also, not there in the finding. Now, Your Lordship quickly takes the finding, page 208, Your Lordship. Your Lordship, I had challenged this order only on the ground that I had cited judgment that penalty under 114 is not applicable in case of valuation dispute on the custom broker. On this point, Your Lordship, I had relied on a judgment in World Cargo Movers, which I had shown to the adjudicating authority. Your Lordship, my written notes to the adjudicating authority is at page 173, Your Lordship. Your Lordship, he has not considered the judgment cited by me. Page 173, paragraph 12, Your Lordship. Next page, Your Lordship will find World Cargo Moves. This judgment, Your Lordship, I've already handed over. This says that valuation is not the domain of the custom broker. To substantiate that your lordship, I can hand over one more judgment of Delhi High Court Division Bench, your lordship. Your lordship, it may be marked, your lordship. I have already
But
handed
my lord, kindly note the huge gap between the declared price and actual price.
Your
my
lordship,
lord.
that has nothing to do with the broker, and that is not the allegation. The allegation is due diligence. And your lordship, I am saying that valuation is not my domain. So your lordship, I have relied on judgment on this point. He has bypassed the judgment. Your lordship kindly takes page 207 and 208, your lordship. First, your lordship, 208. Your lordship, from the middle of the 7th line in the first paragraph. Your lordship, there are threefold submissions, your lordship. Therefore, it is evident that the custom broker has made no effort to meet the exporter in person nor physically verified the firm address. Your lordship, this is the first point. I had handed over judgments, your lordship, to judgment of division bench of our high court that custom broker is supposed to check the documents and verify the correctness of the KYC, GST registration, IEC code. He is not supposed to go and physically verify the client. Second point, your lordship, when the declared value of the goods and there are huge export benefits and input credit involved, it is difficult to digest, and that the custom broker would not take the minimum step to know the exporter and just rely on third party to facilitate fraudulent export. Therefore, the culpability of the custom broker in case of grossly overvalued export attempt cannot be ruled. Has your lordship found that, your lordship? Your lordship, page number 207 and 208, your lordship. Your lordship, file placed from page number 207, your lordship. Point number 34, your lordship, at page number 207. Your lordship, in the first paragraph, he is summarizing the allegation in the show cause. Then, your lordship, in the second paragraph, he is dealing with my reply. Your lordship would kindly see the last line of the second paragraph. The custom broker also cited certain case laws and requested for withdrawal of the show cause. So, your lordship, this is how he deals with the judgment of the learned Sistat, which I relied upon in my written notes. My specific contention is that you are imposing a penalty. You are proposing to impose a penalty under 114. It is not applicable to me being a custom broker and this being a case of overvaluation. Your lordship, he has ignored the judgment. And your lordship, this single sentence, he has discarded the judgment. On that point, your lordship, I had relied on a division bench of our high court in the case of Aarti Overseas. May I hand it over again, your lordship? And your lordship, I had also relied on a judgment of the Honorable Supreme Court in Union of India versus Kamlakshmi Finance, that tribunal's judgment is binding on the adjudicating authority. He should have considered it and not discarded it just by saying that he cited certain judgments. Your lordship, this is neither here nor there. He is not saying that you are liable to penalty under 114. When I am taking the specific point that penalty under 114 is not applicable to me, your lordship, he ought to have decided on this point. He has bypassed this point, your lordship. This, your lordship, from my written notes at page 173, your lordship will find. (173), and your lordship, if your lordship turns the page to 174. Your lordship, here I have relied on the first judgment, your lordship, World Cargo Moves. This judgment, your lordship, specifically says that, your lordship, the custom, no penalty under 114. Your lordship, this judgment, your lordship, has, your lordship. Your lordship, I had relied on paragraph 6. Yes, your lordship, it is on, your lordship. Your lordship. So, your lordship, when I am citing this judgment, he ought to have dealt with it. He has bypassed it by that single sentence, your lordship, at page 207, that custom broker also cited certain case laws. He has not dealt with. And your lordship, this itself, your lordship, deserves that the matter should be sent back for adjudication, your lordship. And your lordship, to support my contention, your lordship, I relied on Aarti Overseas and also on the judgment of the Honorable Supreme Court, your lordship, reported in 1992, that this was a binding precedent for the adjudicating authority. Now, your lordship, the second point is that custom broker is not supposed to physically verify the address. That too, your lordship, your lordship. And your lordship, on the last occasion, had also handed over one more division bench, your lordship, of our high court. Your lordship. Your Lordship. And Your Lordship, the third point is that it is on surmises and Your Lordship. And Your Lordship, the third point is if Your Lordship sees
My
the
lord,
finding.
kindly note that custom broker was acting on behalf of department. He was fully aware of the price gap, my lord. That is not negligible, my lord. The goods which are being sold in market at rupees 18 or 20 was declared at 200, 250 and 300, my lord. There was a huge gap, my lord.
Your Lordship, the finding is only lack of due diligence. There is no allegation of any abatement or
My lord,
Your
under
Lordship, it is
custom
surmise.
custom
Your Lordship,
broker
my learned friend will finish, then I will, Your Lordship, make my point.
under custom broker licensing agreement 2018 and under point number E, my lord, he was supposed to exercise due diligence to ascertain the correctness of any information which he imparts to a client. A custom broker licensing regulation to my lord, point is marked, my lord, point E. Eighteen, 10E, my lord. Grateful, my lord. No, my lord. That's all from my side, my lord.
Your Lordship, I'll just take 2 minutes and summarize, Your Lordship, my submission. Your Lordship. Your Lordship.
Kindly record my submissions,
Your
my lord.
Lordship, I have already handed over a list of data and written notes, Your Lordship. Your Lordship.
Kindly record my submissions, my lord.
Your Lordship. I'm grateful, Your Lordship.
Lord, I appear for the respondent. Your Lordship may kindly recalls that Your Lordship had taken a jurisdictional issue as to whether this matter, whether this matter will be before this determination.
Lordship, we have written a letter to the registrar original side. So what has happened is that this matter was heard on 9th. We wrote a letter on 10th. So when I inquired about this letter was forwarded by the registrar original side to the deputy registrar legal. Thereafter sent to the current records department, and they have recorded a comment that we are unable to determine the determination. Thereafter, yesterday only I know about that comment, and I wrote a further letter to the registrar to place the matter before OSD. So now I just got to know the status that the letter has been placed before the OSD. No action has been taken as of now yet, but just been placed.
I would just like to indicate one thing, Millard, that this has to go before the court having Millard residuary jurisdiction. The reason being, Millard, they have issued a notice under Section 21 of the Arbitration Conciliation Act, seeking the amount which is Millard, which is the subject matter of this instant writ petition. So, Millard, it cannot be that in two different forums they can have the same remedy. So this has to go very well, Millard. Your Lordship is keeping the matter on. After 10 days. Very well. Grateful. Order koriye na. Huh?
12th, my lord, I am for the petitioner. My lord, this is quite some time now, miss. Then, my lord, kindly keeps this matter after the elections are over, my lord. That will be better, my lord, in my understanding, my lord. Elections, my lord, in my understanding, it's supposed to be on 9th and 10th. My lord, kindly keeps after 15th March, 16th March. Very well, my lord.
हेलो बोल जल्दी बोल क्या है कोर्ट में केस चल रहा है क्या हुआ
दीदी को बोल दे रहा था सर ये फैंसी स्टोर के बारे में बात
हाँ क्या हुआ बोलना
बोल रहा हूँ ये लोग जो बोल रहा है इन लोग ठीक है कंपोजिशन स्कीम में हम लोग गए वो ठीक है लेकिन जो एनुअल टर्नओवर होता है हम लोग का उससे टर्नओवर काम करके पेमेंट किया गया था बोल के लोग एब्सेंट ऑर्डर मारा है
जो भी है
Matter, Your Lordship, a very short point is involved. But in this case, Your Lordship, the department had initiated reassessment proceedings during the pendency of CIRP proceedings, Your Lordship. On the previous occasion, my lord had instructed us to prepare an affidavit, so supplementary affidavit, bringing on record, Your Lordship, all the up to date, my lord, all the orders passed by the CIRP by the NCLT. Your Lordship, the matter, my lord, the status is that it's reserved for orders, Your Lordship. There was an intervention application also filed, even that is, Your Lordship, reserved for orders, and even the final CIRP proceedings, as in with respect to the proposal that's been filed.
This is for the claim application. This is the application for claim.
CIRP proceeding.
Yes, the person also is a form. Give it all. 1 minute, sir.
But then, nonetheless, Your Lordship, the proceedings by the department, they are bad in law, and I've relied on a decision of the Honorable Division Bench. But in this matter, my lord, because Your Lordship, yes, Your Lordship, and Your Lordship, in this case, if I may just briefly indicate, Your Lordship, that before the assessing officer, Your Lordship, the CIRP I don't, the IRP, Your Lordship, I apologize, and he is the petitioner in this matter, Your Lordship. He had indicated the fact that the IRP proceedings had been initiated, and my lord, he had relied on a decision of this honorable court in case of Your Lordship, McNally Bharat. But my lord, the assessing officer relied on the decision of the Honorable Madras High Court. He did not deal with McNally Bharat. He relied on the decision of, in case of Dishnet, passed by the Honorable Madras High Court. Your Lordship, the division bench of this Honorable High Court, my lord, has considered Dishnet and has considered another decision of the Honorable Delhi High Court, and Your Lordship has distinguished and disagreed with the decision of Dishnet, and my lord quashed the reassessment proceedings where Your Lordship CIRP proceedings had been initiated and moratorium was in place. I believe a Shea equipment, Your Lordship, I may have handed it over.
Resolution plan application is a full order.
Yes, Your Lordship. But Your Lordship, irrespective, my humble submission would be that Your Lordship, once the moratorium is in place, he has to make the claim. Any proceeding, Your Lordship. Institution of any proceeding, Your Lordship. Lordship, even the decisions of this Honorable High Court in McNally Bharat. My lord. Let's do that. I've handed over one of the first decisions. Your Lordship, this is 170 Taxman Platform 268. Your Lordship, para 5 and 6 is where the facts are, and my lord, para 22 is Your Lordship where the the primary portion of the judgment. Sure. Para 5, Your Lordship, on 19 December 2020, the NCLT approved the resolution plan. And in fact, paragraph 4 on the Bank of India subsequently initiated proceedings under Section 7 of the Insolvency and Bankruptcy Code 2016. And there are other decisions also, Your Lordship, if I may show. One decision of HNG in that matter, Your Lordship, it was a case where the department had filed an appeal under Section 268. Your Lordship, that was disposed of by the Honorable High Court, saying that the moratorium is in place. I'll just. Page 3, एक और copy दो. ये. Page 3-4. And we have heard Mr. Learned Standing Counsel for the Apparent Revenue and the Learned Advocate appearing for the respondent. The Learned Advocate appearing for the respondent submitted that as against the respondent, assessee proceedings have been initiated under the provisions of Insolvency and Bankruptcy Code, and the National Company Law Tribunal has appointed insolvency resolution professional, and moratorium has been granted. To the said effect, the order dated 21st October 2021 in the matter of DBS versus Hindustan National.
My lord, your lordship will kindly see, my lord, page number 55, not this 148. I'll take only 5 minutes time. Lordship will kindly have page number 55, which is order under section 148A3. Straight away, lordship will kindly come to, my lord, page number 58, paragraph 5. My lord, 5.1, my lord. During the period of moratorium, no claim for recovery or levy of interest on the due is being enforced on the assessee by passing the order under section 148A3, which is based on the finding of irregularities of the corporate debtors. The assessee becomes company. Action is being taken merely for the income escaping assessment for the assessment year 1920. It may be mentioned here that section 179 empowers the department to proceed against the directors of the company during the relevant period, who shall be jointly and severally liable to pay payments of such dues for the company which could not be recovered from the company itself. For this reason, it is necessary to arrive at a final tax due for the assessment year 1920 respect to the assessee company. The liquidation process is no way can impinge upon the rights of the income tax department to pass the order under section 148 Act. It is further be mentioned that the liability that the hearing of the section 179 of the Income Tax Act before the 1/4/2022 was the liability of the directors of private limited company in liquidation. The word in liquidation was omitted by Finance Act 2022 with effect of 1st April 2022 from the amendment itself. The intent of the legislature is very much clear, and that the liability of the directors of the private limited company continues irrespective of whether the company is under liquidation or not, as long as the tax dues was not recovered. So in this case, Dishnet was cited, not yes. Resolution, yes. Fails, yes. Yes. So that yes. 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 Yes, yes. If fails, then liquidation comes. Yes, yes. Yes, yes. 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 That's differently. Yes. So, my lord, this dishnet was, my lord, considered by our court, my lord, in my lord, Stray and also my lord, McLean Bharat, and held that no, you cannot proceed, my lord. So I'll not because division bench has already considered it. So, my lord, this is the fact, not so that is the because only not here it has not been completed. It's pending. That their NCLT proceedings is pending. Yes. 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 Yes.
Yes, Your Lordship.
Yes, yes. Well, I think it's pretty.
I made a photocopy for that. Yes, Your Lordship. Institution of suits.
Yes. Yes.
Your Lordship, even with respect to section 179, but I had on the previous occasion, I dealt with this point. I had handed over a copy of the finance bill, my lord, but only once on clauses. But if I may just indicate your lordship this point. But there, my lord, this provision, my lord, section 179 deals with the liability of directors, not in case of liquidation, but in general the case of liability of directors in case of a company that is existing. So therefore, your lordship, the word in liquidation was deleted. So this deletion and this section is in my favor, not against me. So I would kindly take that notes on clauses. My clause 55, but I had provided that earlier, your lordship. It says that clause does my lord have a Clause 55 seeks to amend Section 179 of the Income Tax Act relating to liability of directors of private company in liquidation and provides for recovery of. This is my. I'd handed over my. But in the middle of the page, Your Lordship. Paragraph, third paragraph. But clause 55, page 251, my lord, on top of it is written. Only notes on clauses. You have to notes on clauses. Yes, Your Lordship. It says, Your Lordship, that clause 55 seeks to amend section 179 of the Income Tax Act relating to liability of directors of private company in liquidation. It provides for recovery of tax dues of a private company from its directors in cases where such dues cannot be recovered from the company itself. The marginal heading of the said section as liability of directors of private company in liquidation. However, the provision of the section do not deal with companies in liquidation. Therefore, it is proposed to omit the word in liquidation from the marginal heading of the said section. It was actually a misnomer, my lord, which was corrected. My lord, this analysis of the assessing officer is incorrect. In fact, it comes to my favor. My lord, absolutely. Yes. Absolutely. Yeah. Absolutely. My lord. My lord.
By this process, we are not recovering anything. We are asserting something. There's no recovery. Assessment, there's no demand. Yes, yes. 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 Monday, yes.
Ask the meaning for my. Or Wednesday 15th. I'm grateful.
Okay.
Hallelujah for the response. Mr. Dugar is for petitioner. Dugar, Anil Dugar.
Like 14 and 15.
Both. Same assessee.
item number 16. In this case, my lord, my assessment was completed in 22. Vivad se Vishwas scheme came applicable from 1st October 2024 and continued up to 30th April 2025. This Vivad se Vishwas scheme continued up to 30th April 2025. I filed appeal. The condition was that appeal should be pending on 24th of July 2024. In my case, what has happened, appeal was disposed of in the month of May 2024 ex parte without giving me any opportunity. I filed an appeal before the Honorable Tribunal. Honorable Tribunal restored the appeal to the CIT appeal. So my contention before the PCIT was that once the appeal is restored, it relates back, pendency relates back to the date of filing of appeal. But that has been rejected by the PCIT. And my lord, I am covered by the Supreme Court judgment that once the appeal is restored back, it relates back to the date of filing. In tax matters also, same thing has been taken, same view has been taken by the Honorable Delhi High Court.
Your Lordship will kindly take page 111. This is the order, Miller, rejecting his application under Vivad se Vishwas. This Miller is not default, on default, dismissed on default. So it was dismissed on merit. Miller, against that, he went up in to before the tribunal. So Miller, his allegation is that they should be heard afresh. Now Miller, if it is dismissed for default, then there's a question of hearing afresh. But Miller, here I find Miller, subject to correction, Miller, it has been dismissed on merits.
My lord will kindly see last but third line of this order, where an appeal is not pending on 22/2/2024. This is what has been mentioned in the rejection. And my submission, my lord, is that once the appeal is restored back to the CIT appeal,
From demand. Now, in a case where it is dismissed for default, it is restored. Where it is dismissed on merit, the authority decides the appeal over the order of dismissal on merit.
my lord,
Then we step on demand. So, what difference?
my lord will kindly see the order of the CIT appeal. My lord will kindly come to the order of the CIT appeal. He has passed the order ex parte. Page 64, annex 3, page 64. Page 67 is the operative portion of the CIT appeals order.
57. Decision. I have carefully gone through the facts of the case. More, all the notices were duly served upon the appellant through email. The appellant opted not to respond to the above notices for the reason best known to him. No concrete documents were produced before me in support of GOA or the rebut the assessment order. In view of the above, it is clear that the appellant is not interested in processing the present appeal on merits. In the absence of evidence to rebut the assessment order is confirmed. Accordingly, the appeal is dismissed. So the dismissal is for non-appearance. Is not considered on merits. And the order of the tribunal is kindly, my lord will kindly come to page 69. Para 6. We, after hearing both the parties and reviewing the materials on record, find that the order of the state is ex parte order denying adequate opportunity to present the case by the SSC. We note that the state will dismiss the appeal of the SSC without going into the merits. We therefore find the dismissal of the appeal solely on procedural ground without examining the merits of the case, which is essential. It is not justified. In the interest of justice and fair play, we deem it fit to provide the SEC an opportunity to substantiate the case of just and fair assessment. We therefore remand back the issue to the file of the CIT appeal. Therefore, my lord, it is, my lord, but language, whatever it is used, it was ex parte order by CIT appeal without going into merits. And it has been, my lord will kindly see, the appeal is, it has to be heard by CIT appeal on merits. Because I cannot command, my lord, the language of the honorable tribunal. But the essence of the order is that the ex parte order was there, it has been sent back to the. No, my lord, no, my lord.
Yes. Millard, may I come back, Millard? Yes. Because today I have lot of things
this and item number 24 are
34.
24 are similar to the other matter that he had been, my lord was hearing, which he was submitting, my lord, as fixed on 2nd March. 17 and 20.
And the other matter, I proceeded, but because of my fault, I couldn't cite the page, the difference. That took time of the court, the court was trying to put it on the
2nd of March.
So
My
these
lord,
three matters are the same matter, that is, are both. 2nd March.
my lord, kindly passes an order that this was will be taken up. It will help us.
24.
My junior has been, my junior will be, has been waiting all afternoon for this.